watching from my office? This is live. I haven't sent any data to the camera.
I think so, from my office, but anyway,
How's it work?
that's why this is my office.
What is it? What's the refinish?
Show your thought, Brian.
John, there's a couple of local walks floating around that I need you to.
Call the meeting to order. Salute the flag.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The time, date, and location of this meeting was published in the Asbury Park Press and posted on the bulletin board in the office of the Township of Lakewood at least 48 hours in advance. The public has the right to attend this meeting, and minutes of this meeting will be available for public inspection. This meeting meets the criteria of the Open Public Meetings Act.
Roll call, please.
Mr. Grunberger, Mr. Franklin,
Here.
Mr. Hipperson.
Yes.
Mr. Flansbaum, Mr. Herzl,
Here.
Mr. Renner, Mr. Coleman, Mrs. Zabrafos, Mr. Cotillo.
Swearing of Master.
State your name for the record, please. Do you swear or affirm the testimony you give here this evening will be the truth, the whole truth, and nothing but the truth?
Yes. Before the members of this, now we can just say who's here.
Yes, SB 2059AA, Mr. Grunberger, you know what, should I just take a roll call? Okay, 2059AA is not Mr. Renner, Mr. Coleman, or Ms. Zabrafos. Everyone else is good. Let's take a motion.
We have a motion, for number one.
Second.
All in favor?
Number 2, SB 2221AA, Mr. Renner's the only one who cannot vote on that.
We have a motion. Second. All in favor?
SD 2180, not Mr. Everyone who's here to vote on it.
All in favor?
SD 2183, everyone who's here to vote on it.
All in favor?
And SD 2185, Mark Properties, Terry has some comments before we move on.
Yeah, Chairman, I want to follow up on this application. If you remember at the January hearing, this was a minor subdivision that was approved at the intersection of Cross and Building Street. We had noted in our review that the existing intersection was substandard, and we recommended improvements. At the hearing, there was considerable testimony that the engineering office somehow let the people who were doing work across the street put the curb back in the correct place. We were directed to contact the engineering department and find out what happened, assuming that was true. What we found out was the information that was provided at the January hearing relative to Cross and Biltmore was completely and totally false. Per information given to the planning board in 1995, that curb has been in that location since 1995, which is about a decade prior to any significant improvement in that area. So relative to this application, our recommendation was and still is, we recommended that the applicant agree to upgrade the intersection to applicable township, county, and RSIS standards. Now, one step further, although I can't guarantee this, I have had communication with the mayor relative to, do we work with the applicant as a township and put the road back where it should have been 20, 30, 40, 50 years ago. There is a possibility that if you approve this, we're going to work with the applicants and possibly look at a cost-sharing plan with the township, and this application, I wanted to give you that information for the purpose of the resolution.
What
Now,
happened 1995? How did that road get sold?
the road was, we went back, the engineering department pulled aerial photographs dated back to 1995. The alignment of the road was always met. Now, at that time, there were only 2 or 3 homes in the area, if you look at the areas. We had given the board members copies of this. The mid-2000s, there was a major subdivision that was approved. We were not the engineers at the time, I don't have particulars, but it wasn't fixed at that time. Probably should have been in retrospect. That's why the township is looking now and possibly saying, we may go back and look at a cost sharing to put it where it should have been all along.
Are we memorializing this?
I would memorialize the resolution as written with the you don't know, but at a minimum, they've committed, the developer's committed to making the intersection safe per applicable standards. If we can work out a cost sharing agreement to fully realign it, that'll be done. If it can't be worked out, the applicant is still responsible for improving the cartway per applicable standards and also counter approval.
Unless it's not approved.
Correct. Now, applicable standards is per the residential site improvement standards, which is based upon road design, level intensity, traffic. We also need to get Ocean County's approval because of the connection of the intersection to Cross Street. That was- We do, I cannot tell you tonight it's gonna be exactly 26 feet, or 28 feet, or 30 feet. This needs to be reviewed further. It's gonna be,
It's gonna be according to the
it's going to be per what is required for the applicant. The township and the county may take it further, but at bare minimum, it's going to be per applicable minimum standards.
much better than what's right.
Absolutely.
Mr. Vogt, you said that some of the information was inaccurate about the location of the curb. You're not talking about information provided by the applicant.
No. I'm talking about testimony that was provided at the meeting. And I'm glad that you brought that up, John. People are encouraged to come here and give testimony. That's the purpose of the meeting. And everybody should obviously be encouraged and give testimony on applications if they have concerns. As a board, my recommendation to you is that engineering testimony should come from engineers. Planning testimony should come from planners. Legal testimony should come from lawyers. If you hear testimony from someone who does not have the credentials, I say this respectfully. You need to take that into your decision making.
Yeah, so I just want to make sure, because you said there was some inaccurate information. My recollection is that the applicant at all times said they didn't touch it, they didn't move it, and some objector said that must have gotten moved or whatever.
There was testimony that the engineering department let the curb get put back in the wrong place
And
as a
here-
result of the school development that is going across the street. You have the person developing the school here.
Okay, I just want to make clear, and you're in review after hearing that, you went back and you checked the aerial photographs and you're satisfied and your recommendation is for
The curb has been where it was since 1995.
And the important thing is that you are going to work with the applicant as the municipal engineer and as the
Correct.
board engineer to make the road safer and comply with standards. And you and the municipality will be satisfied that it's built in an appropriate manner.
If the board memorializes this resolution tonight, one of the requirements is they will need to come back with a development plan that widens the intersection to applicable minimum standards.
Okay.
If nothing else happens, that will be done.
Okay.
Our hope is,
Yes.
with the township's consent and with the assistance of the township and the county, it may go a step further.
Thank you very much.
Quick question on the school, because you're here. Did the school do anything wrong in their application?
Thank you. My name is Abe Albeck. Abe Albeck. We did a school. My name is Abe Albeck,
Yeah.
Lakewood, New Jersey. We did the school on Cross Street. Built
Just
more.
understand that you wanted a course.
I wanted a coffee.
Well, I don't really, I don't.
We
know if
didn't any
that's
propose-
appropriate. Mr. Vogt made his recommendation.
Okay.
Are you satisfied with Mr. Vogt's?
Yeah, it's completely accurate. We didn't touch it. We didn't do anything.
There's really no reason.
Did your plan show that?
Always
The
plan
curb
showed.
is
Always
on your
plan showed exactly what's there. We did a minor repair, maybe 4 or 5 feet, a repair that broke during construction. The curb and road always was there and continues to be there as is the past, like you said, 15 years.
That's my
talking about different applications. The application that Mr. Auerbach is building is a pre-existing school. The existing access was off of Cross Street, about 150 feet north of this intersection approximately.
It's, yeah, exactly.
Okay. The access.
It's the other side, correct.
The new access is the same.
It always was on Cross Street, always stays on Cross Street.
Yeah.
We never touched it. Totally, nothing on Biltmore. Thank you.
We have a motion to approve this motion. And all in favor? Aye. Okay, number 4.
That was number,
And number 5.
Mr. Jackson, do you want us to continue on, or did you have an application you wanted to?
There is, how many resolutions?
That's it on the resolutions, but we have 4 Oak Street admin minors and some ordinances.
Mr. Chairman, with your permission, if I may, I'd like to address number 6 on tonight's calendar, a preliminary issue with it. On tonight's public hearing calendar, number 6.
Sorry, Mr. Jackson, just a second. Before we start that, can we carry the 4 items at the end of the application so they don't have to sit here for testimony? There are 4 items at the end of the application that just need to be announced.
Kimberly, can you do this one?
Yeah.
SP 2220 is requested to be heard March 7th, as is SP 2218 Lakewood Shopping Village, as well as SP 2182 BBC Capital. Is Ms. Weinstein here?
2181.
Okay.
She's out in the
SD
hall.
2181 is requesting March 21st.
Miriam, I can see her through the door, she's out.
Assuming the board doesn't have an issue with me scheduling them as I see fit, then do we need a motion to officially carry them and make the announcement?
We have a motion to carry number
Hold
7.
on, I'm sorry, just a second. Miriam, BBC Capital wants to go on March 7th, is that correct? Along with Pine Holdings and Lakewood Shopping Village, or are they looking for March 21st instead?
21st.
March 21st.
That's what I thought. Okay. So, no, item number 7 and 8 are looking for March 7th, and number 9 and 10 are looking for March 21st.
Do we have a motion for that? Move. Okay, roll call.
Mr. Grunberger, I'm sorry, Mr. Franklin.
Yes.
Mr. Hipperson.
Yes.
Mr. Flansbaum.
Yes.
Mr. Herzl.
Yes.
Mr. Renner. Mrs. Graffos. Mr. Cotillo.
No, Mr. Jackson.
Yes, thank you, I'm not
Wait, we need to
requesting.
make the legal announcement on this.
Members of the public, please be advised, applications number 7 and 8 on tonight's agenda, SP 2220 Pine Holdings LLC and SP 2218 Lakewood Shopping Village LLC are now carried to March 7th at 6 p.m. in this meeting room. No further notice shall be given. Items number 9 and 10, SD 2181 Cedarwood Hills Homeowners Association and SD 2182 BBC Capital Group LLC will be carried to March 21st, 6 p.m. in this meeting room. No further notice shall be given.
Okay, thank you. Mr. Jackson.
Thank you. I'd like to call on a preliminary matter, I don't know if that we're going to do the whole case, but on number 6 of tonight's public hearing calendar, Congregation Michigan Torah. I see Mr. Doyle at the podium. Are there any other members of the public here on Congregation Michigan Torah? We're going to consider an aspect of that case now. All right, just, Mr. Chairman, members of the board, I just want to give you a little bit of a background on this. I spent a lot of time discussing this matter with Mr. Gazarovski, as well as with Mr. Doyle, as well as doing research and looking into this further. You will recall that this applicant proposes dormitories as an accessory permitted use. I forget if it's a shul or a school.
It's a yeshiva.
It's a yeshiva, so, the board, on a preliminary basis, we had argument and debate about it with the attorneys. The board made a ruling and said, based on input from Ally, our land use administrator, that that was an accessory use, traditionally to a school, and that the applicant could go forward. And we made a motion on that second, and the application went forward. What then happened is, Mr. Gazarovski filed an action in lieu of prerogative writ, which is starting a court case, an appeal of the board's decision, asking the court to rule on that issue. And at the last hearing, when I had learned about that, I made appeal, and that vested jurisdiction in the Superior Court, and as a result, the board should not move forward. I indicated that the board could hear the case, and then if the court decided we didn't have jurisdiction, then it could all be for nothing. In the meantime, for some reason that I don't know why, it was put back on the agenda, and it's on the agenda for tonight. I think that was at the request of Mr. Pfeffer, who was counsel for the applicant at the time, if my memory serves me. No, Mr. Doyle's the applicant's attorney now. Were you the attorney all along?
No, Mr. Brown was the applicant at the beginning. It was put back on the agenda because after discussion with you and Ms. Morris, I asked that it be put back on the agenda with the reasons, knowing that the only person really who would be most harmed by putting it on the agenda, if it ought not to have been, is my client, and we were willing to accept that. And we come here tonight ready to proceed.
So the way I analyze the issues here, traditionally, fundamentals of appellate practice in court, once someone files an appeal from a lower court action, the jurisdiction is then vested in that higher court. And if you want relief in the lower court, you have to go to the higher court and ask for relief, ask for a remand or ask for, basically a ruling from the higher court that the lower court can retake jurisdiction. There's some.
I apologize.
I tried to do research on that issue. I can't find anything that specifically prohibits a planning board from hearing a case once someone files an action in lieu of prerogative writ. And the reality is, a planning board is not the court. It's a quasi-judicial entity. It's in many ways like a court, and in many ways, it's not like a court. Our decisions go to court, and then it becomes a court action, goes to Superior Court, and then from there to the Appellate Division, from there to the Supreme Court possibly. But certainly, it's not set up, our rules and regulations are not set up where the court rules apply to it, governing an appeal. And what my concern is, that an applicant, not an applicant, an objector could unilaterally, let's say our meetings are at 6 o'clock, let's say someone goes into court as an objector on a case we haven't even looked at yet, for $200 or $250, whatever it's up to file a complaint, no judge looks at it, and they could come here and waive it and say, oh, you can't hear the case tonight, effectively obtaining an injunction against a court. And I don't think that's a proper procedure either. I don't think that an appeal should, where the board hasn't decided a case yet, act as an automatic stay or an automatic injunction against a board from proceeding. There are procedures like that in court, like if you file a federal appeal, or if you make a motion to remove something to the U.S. District Court from Superior Court in New Jersey, it stops, but that's by federal statute. I know of no statute, no doctrine, no case law that says that when an action is pending in front of a board, then someone filing an action in lieu of prerogative writ, which is effectively an appeal, that serves as a stay against the board action. I also note that the board has not made a decision on this case either. Traditionally, when there's an appeal, which is where the Superior Court normally gets jurisdiction, somebody has appealed the board's decision. So there's a full record, there's a resolution, there's an official action, and that official action is what's being appealed. That's not what we have here. The board hasn't heard this case, hasn't decided what to do, and there's not an actual appeal. It's effectively someone trying to get an injunction against the board action. I think it's a difficult call, and I think it's a call that the board has to make. I see the downside to proceeding while the appeal is pending. The downside is that the court might say we had no business going forward, and then it's all moot. And at that point, we might have to do over. I think the greater risk for that is on the applicant, although there is certainly an imposition on the board because time, what the public goes through. I think the board could be within its rights to say, look, we're going to wait until we get direction from the court on whether we do this. The other side of the coin is an applicant has filed a matter, it's in front of the board. I think an applicant has an expectation and a right, and there's also something inherently proper in it following its course and not getting it derailed by an objector filing an appeal really before the appeal is actually right in my view. So I think those are the things that the board has to consider. Mr. Gazarovski, I spoke to him at length about this, and in fact, on the car ride over here, I was still on the phone with him. He told me he's not coming here tonight because he thought that it was put off, which is another
Mr. Chairman,
Say something?
and members, yes, I'd like to speak for
Yeah.
a couple of points. One, every legal matter starts with the facts. What are the facts here? Facts are that an application was made by Congregation Mishkan Torah. The board found that application through its administrative staff to be complete. The congregation made notice in accordance with the law. The board, through its administrative staff, found that to be complete and scheduled the matter. The applicant came before the board. There was legal counsel on behalf, allegedly, of a person different than who Mr. Gazarovski represents now. We've later determined that that person had no objection to it. I don't understand why that is, but there was a lawyer who objected to the board taking jurisdiction. There was a lawyer for the congregation that said the board had jurisdiction. The board heard conflicting arguments, legal and factual, as to whether or not it had jurisdiction. The board made a reasoned, factual decision based upon the evidence before it that it had jurisdiction. On that basis, they were to go forward with the application on February 7th. A complaint was filed on, I believe, January the 17th or January the 20th. The fact that that was filed 2+ weeks before the hearing was not discovered until the morning of the hearing, when the attorney then told Mr. Jackson and the board that it was. I appreciate that finding out at 11 o'clock that a lawsuit was filed for a matter that was to be heard at 6 o'clock, the attorney and staff understandably said, scratch their head and says, we got to figure this one out. At this point, I became involved. I asked that we be clear about what happens on the night of the 7th, that notice be given that this matter will be reconsidered on February the 21st, and so we are here. So we procedurally have a right to be here. Now, the question becomes, is that changed by reason of this lawsuit? The analogy to the appellate proceedings in a trial court, in a superior court, appellate division, Supreme Court, is understandable in a pure court setting. For all of the things that are here, a court reporter, notice, this isn't a court, this is a planning board, to be respected. And part of respecting that planning board is when they accept jurisdiction, what the law says is clear. It should be noted that a board may not refuse to exercise its jurisdiction or hear a matter properly presented. Application complete, notice complete, hearing scheduled, vote to take jurisdiction, we have jurisdiction. So we have a right to be here. Citing Cox, it is within the inherent jurisdiction of the board to determine the meaning of an ordinance in connection with the pending application. This the board has done. It would appear that any incidental ordinance interpretation belong properly with the planning board and then with the courts as part of an appeal process rather than with the zoning board. So all through this, it's been proper. Now, the filing of the lawsuit. That lawsuit could have asked for an injunction, stop you. It didn't. It could have asked for a stay. It didn't. What that lawsuit tried to do is to bully you, in a sense, to say, oh, put up my hand and stop you. One objector, if an objector, as Mr. Jackson rightly points out, at 5 o'clock, walks in and says, I filed a suit. And you had citizens here ready to, and experts, that wouldn't be right. That wouldn't be right. So more than that, though, let me just say to the board, your determination was right, not merely because you made it, but because the law in the Monmouth University case holds that dormitories are an accessory use to a principal use that is a school of higher learning, which is what a yeshiva is. So your decision was made, your decision was right, the application is complete. It's all of the law and all of the facts against a piece of paper called a complaint. To shrink from your jurisdiction would be wrong under the facts that you have set rightly, that you have jurisdiction. It would be wrong under the law that I cite in the Monmouth University case. But more than wrong and improper and not in accordance with the law, it would set a terrible precedent that one person can hijack the board. I ask that this not happen. I ask that we continue with the case. We have our witness, we have our expert for a noticed hearing that we wish to proceed with. If there's questions about either my presentation or the quandary that it is thought that you should be in, I'd be glad to answer them, but I think the best way to answer that quandary is to go forward. The only people who would be hurt, as I say, are us if we have to come back. The objector who chose not to be here always has the ability to go to court.
If it has to come back, it doesn't come back to our board. If the judge decides, then it goes to the zoning board.
If the judge were, and I certainly lean on Mr. Jackson, I think, as Mr. Jackson said, typically a court has a full record. The only way to develop a full record is to have a hearing. If he wants to amend his complaint and say that it should have been before the zoning board, and even if it should have been before the planning board, you decided it wrongly, there'll be a record. Judge could do a few things. He could say, you're wrong, affirm. He could say, the planning board had jurisdiction, and maybe they shouldn't have decided the way they did. They could say that the zoning board should have decided it, and go against what has been precedent in this town and the zoning officer's own determination. The the objector could have gone to the zoning board and sought out that opinion. They didn't do that because they knew what the opinion was. So they can't do what they've done without being unfair to the public, to the applicant, and most of all to the board.
Me personally, I don't know, maybe we should take a vote, but me personally, as long as you know it's on your own risk, the only one.
There's no question.
I don't have a problem listening to it.
It is at our risk, and I understand that, and on behalf of my client here, they understand it.
Board, we can't proceed anyways.
I understand.
To answer your question, it was, the court on appeal from the board's decision has several available options. One would be to remand it to the Board of Adjustment. They said that accessory use doesn't belong to the board. I think that would take away the planning board's jurisdiction. The court could affirm the board, or, usually if the board gets reversed, there's a remand, but the court can, in exceptional circumstances, make the ruling on the merits of the application. But almost overwhelmingly, if there's a reversal, it gets remanded back to the board.
As far as I know, the zoning board, the zoning officer also said that it belongs,
Yes.
that's an accessory use.
Yes.
I feel comfortable that we should listen to you.
Well, I would then, ask for a motion, whether we go forward tonight on the,
So moved.
Second.
Okay, so roll call?
Well, I wouldn't ask for a motion. I would say, if I were you, I would ask. for a
Yeah,
motion.
just that.
Mr. Franklin.
No.
Mr. Hipperson.
Yes.
Mr. Flansbrough, I'm sorry, I have you out of order.
Yes.
Mr. Herzl.
Yes.
Mr. Renner.
Yes.
Mrs. Zagrafos. Mr. Cotillo.
Yes.
Okay, and I kind of took this over because I have Ms. Bennett here tonight to cover for me. I have to go to another matter tonight. I came here for this. I don't know if you want to continue with this or take your agenda in order.
Things to go in order.
Okay,
So
so
take your.
thank you, Mr. Doyle. We got that issue.
Thank you.
Put aside, we'll get back to your case at the appropriate time. So no one leave on that. If you're here on number 6 tonight, we just took that preliminary aspect of the case first, and we'll go back to the application. Yes, yes. I understand you have an issue also with the.
Oak Street Court Residential Development. Do you want me to announce each one individually, or do those all at once like we did last time? We have 4 applications in the Oak Street Court
set up in a way where fully complying applications were not to be reviewed by a subcommittee of the planning board to make a determination if they were fully compliant with the ordinance, in which case the planning board would give, the subcommittee of the planning board would effectively give administrative approval. Very similar to the way if somebody comes in with a lot in town, building plan, the house meets all the criteria, the zoning officer signs it. With the Oak Street corridor, the governing body wanted a little more scrutiny than that. And there was a lot of debate, who would be on the committee, where we would do it, et cetera. And the planning board, to have full transparency on it, decided that the full planning board would be the committee. So the thing we're feeling our way with is, to what extent does the public participate this? I think, as a committee, just like the zoning officer doesn't take public comment when somebody comes in and asks the zoning officer for a permit. If you want to get a fence put up, you fill out your application, it gets done internally. It's not public comment. These don't require notice. So I do not think that this board is required to take public comment on it. However, it is certainly within your authority and discretion to allow someone to comment on it. I know you have the 4-minute rule. Maybe that's another measure of protection. Maybe someone from the public would point out that it doesn't apply.
I just feel more comfortable, because I notice people think that we're trying to bypass the law, we're not making community centers, we're not making sidewalks, by making it the Oak Street corridor. That's what we're bringing to the board.
It's certainly your authority and your discretion as the chairman. If you want to hear someone on a matter, you can certainly allow that. And you don't have to either.
Okay. I don't think we have too many people in. Ryan, you want to speak on it?
I have nothing to say. I'm here to answer questions. I think, as John pointed out, these are all conforming. There's really nothing to be said, but if there's questions, I'm here to answer them.
Okay, so let's, Mr. Klein,
Can I just ask, you can come up.
okay.
Okay, no, come.
You can come up, but please limit it to 4 minutes.
I'll try to limit it as much as possible.
Just please state your name for the record.
Shlomi Klein, 189.
This is not a formal matter, Mr. Klein. You do not have to be placed under oath.
Okay, thank you. All these,
It's always a good idea to tell the truth.
yeah. The 4 applications that we're talking tonight over here is on Pinehurst. As you know, Pinehurst does not have roads and sidewalks on the application. Terry in his letter did not point it out. We went back and forth, but by the end of the game, there's no roads and sidewalks over here. As you look over here, there's another development. I see Brian took this off. I could put it back, I hope so. There's another whole development that is being built now that this is connecting to Pinehurst, the whole thing over here. This is the only cross intersection that connects from north to south, versus this one is not connecting and all the other ones. So it's, as a grid parent, taking out these roads was a mistake, and the township committee did not vacate it for that reason. Now, as you're talking about road and sidewalks, John, I mentioned last week that because no roads are proposed, no sidewalks is required. But when I looked up the ordinance, it says that the developer has to put in roads. And as the frontage of the property, even though this is the side, but as we know, as front yard setbacks is considered frontage. So this thing should have been required to put in roads. No, I know the minutes are going up, actually down. But as you see, we don't know, as a plan is presented to you, you don't know what's going to be over here, if it's going to be parks or it's going to be empty land. They cleared this land from trees. So as a developer coming in and saying, okay, who's going to maintain it? Is it going to be like gravel or it's going to be something else? They went and they put the sidewalks with the drainage, like over here smack in the middle. You shouldn't be able to make roads. The township committee could come back and make the roads. All I'm saying is, as far as administrative approval, when you went and said that everything, they showed you, where's the other one? They showed you this map without the street being vacated. And you saw a very beautiful grid. What they're coming back now is, and they're closing off the grid. That's not what your intent was when you approved it. So, if this doesn't, I'm talking about the legal aspect, if this doesn't need a waiver because of the ordinance says that whenever applicant comes in, they have to approve the road. Now, could be you didn't mention this last time, John, that because the township committee approved it, therefore, and in their plan it was not, there was no roads over there, it was just like, they didn't show anything over there. Therefore, it doesn't, it's still like they waived it automatic. But that's not what Ali represented to the board, and that's not what Terry represented to the board. They represented to the board that there's no waivers, and that's what was recommended to the township committee. So to claim now that the township committee is the one that gave the waivers, and when they got that there's no waivers required, it's like somebody fooled around over here. I'm not saying that Ali fooled around. I'm just saying because when I brought it up with her, she actually went back and forth that there might be a problem. But what I'm saying is, last time you said that you don't need sidewalks because there's no road. But even the road needs a waiver. And the road was not taken care of unless if you use the township committee's approval. And my time is running up. Could I have another minute? Okay. This problem as approving stuff and it's not on the plan is happening constantly. One of the things that is happening is like if you go for a plan, the site plan approval in the planning board and there's no sidewalks. It comes to the engineer, and the planning board does not give waivers. Does it give an automatic waiver because it was not on the site plan? Or you have to verbally give the board or it has to be in the review that you're asking for a waiver? Consistently, we have that plans getting approved by the planning board, that you're overseeing sidewalks, and then when it comes that there's no waiver given, you still require them, they don't put in sidewalks because it was not on the site plan. Could be this is the same problem over here. The township committee approved something without road and sidewalks. It's like automatically given, like when the planning board is doing it. Could be that's the same argument. But the fact is, they said that there is no waivers and there is waivers. And even if you don't take my argument, consider what's going to be with that piece of land. Who's going to maintain it and who's going to take care of it? Thank you.
Mr. Jackson, you want to?
And by the way, thank you for letting me speak.
Okay, you're welcome.
Thank you.
Is that a waiver or not?
Well, sorry, I have to give a little background on this, and, Mr. Klein, thank you for your comments, and, I think when we have people like Mr. Klein scrutinizing what we do, I think overall that's a good thing, because we look at these things closely, and you make sure we do our job the right way. In this particular circumstance, this whole Oak Street corridor, was on the basis of design and a plan that was submitted by the municipality and approved by CAFR. So we have an overriding blueprint. And that blueprint did not provide for the completion of the right-of-way on the streets in green. And why the governing body did not want to have cross streets there, that's up to the governing body. I mean, you don't have to have a grid everywhere. Maybe they don't want the traffic going, down those streets. Maybe they wanted to keep it green. I know CAFR has requirements for impervious coverage on subdivisions that even includes the roadway. You have to take that into account. So it's a complicated puzzle.
The question is it a waiver?
I don't think it's a waiver because our requirement is that you have to put curbs and sidewalks where they're required. Since this is an area that's shown as green on a CAFR plan, roads and sidewalks are not required there. It's not allowed under the CAFR permit. And what we did, and I spoke about this at length with the borough attorney and with the administrator, and they said that the administration has no interest in somebody putting a curb and sidewalk down a potentially green space. It doesn't make any sense. And what we did is, they're meeting their curb and sidewalk requirement because they'll have to do it to the midpoint of the unimproved roadway. So, and this doesn't prevent in the future the municipality from putting curbs and sidewalks in there if they ever decide they need those roadways. That's, if the wisdom, it'll just have to be paid for. They can also assess those particular property owners if they really wanted to.
Technically, if it's a road, it's a responsibility of the homeowner, not of the.
No, that's kind of like a no man's land, because the homeowner, the public still has the right to go over there, it's still a public right of way. But if it's unapproved, you can't drive your car on there, I wouldn't think.
Technically, the two properties, their property ends before that right away.
Their property ends at their property line, and
The gate will go further.
if they got a fence or whatever, and I would think they would not be able to prevent you, me, or anybody else from walking down the area that's green, or riding our bike there, or sitting there, whatever. And if, I would think you could even, take your car through there, but fulfilling their requirement, and that's what my recommendation
And
is.
your recommendation is that we don't need a waiver on?
No, I don't think it requires a waiver, because there's no requirement that a curb and sidewalk go there. In fact, I think that would violate the capital plan.
The roads?
Mr. Vogt, do you have any, comment on that?
Oh, I think it would definitely violate the CAFR plan. They would have to go back and seek an amendment. There are a number of issues that CAFR applications are reviewed on. One of them is impervious coverage.
So we can't even change the plan legally. because
I'm gonna let you talk with Mr. Jackson about what's legal.
Right.
I take my own medicine. I'm an engineer.
Okay.
I don't testify for law.
No, I'm saying, because the CAFR is above us.
Now,
We
in
cannot
terms of
change the plan.
waivers or not waivers, if you look at our letters, our comment number 4, and I'm starting with SB 2201A0 in particular. All improvements in curbing, sidewalk, and pavement restoration must be in conformance with the DEP-approved Oak Street Corridor Improvement Plans by FWH Associates and planning board requests, if any. You know, we had a couple, I think the first application, there were a couple of dead ends, and the applicant volunteered to make a connection. If anything comes up on any of these applications where the board looks at a subdivision and says, you know what, it would be good if we could possibly tweak this, talk about it. You know, I personally think that what's requested on these particular applications, because these roads are not being put in, I think it's reasonable. If the board feels differently, they can certainly take action.
I don't do any signs that go nowhere.
Does it make sense for us to ask, the committee, the township committee, what their intention is?
But if I could, Mr. Chairman, I don't think we have to ask the Township Committee because the Township Committee passed an ordinance that said these are minor subdivisions, which the board should have a committee review, and they should be approved administratively if, and there's a list of things. And with respect to improvements, it said the improvements are in or guaranteed in accordance with the CAFRA plans. So, Mr. Klein had two questions: who's gonna maintain them? And those right-of-ways adjoining your property have to be maintained, just like the right-of-way from the curb to your property line, that you have to shovel the snow and pick up the trash. Between the two, to the center line of the road, those people, if there's trash, they're responsible for maintaining that. So that's a very simple issue. With respect to, is a waiver needed? No, there's no waiver needed because the Township Committee passed an ordinance that specifically said the improvements that are needed for these to be considered administrative minor subdivision approvals to be approved are putting in the improvements in accordance with the CAFRA plans. And as John indicated, the improvements include, if you have a right-of-way next to you, the improvements to the center of the road. Now, putting these improvements in, most of it's in already. All we're talking about is the sidewalk connecting up the sidewalks. And Terry's report says it, the plans will show it. He raised two important issues, but I think it's very clear that no waiver is needed, and those areas will be maintained by the property owners. Right, that right-of-way is a right-of-way that was given to the town for a public use. As John says, anybody that wants to can walk in there. They have full access to it. The township can do whatever in that right-of-way is needed they determine is in the township's best interest.
There's no determination right now what the township wants to do.
Well, there is a determination because the township signed off on the application that was submitted to CAFRA, and the township passed an ordinance that said, put in the improvements that were shown on this plan that was approved by CAFRA. That's perfectly clear.
Now,
One other thing,
where
Chairman,
they
if I
cleared
could.
all that property, how are they gonna leave that for the property owner? Are they gonna grade that off and topsoil it?
There's a soil erosion plan that indicates that any area that gets disturbed needs to be topsoiled and stabilized. So the Ocean County Soil Conservation District will require that anything that was done needs to be cleared. There's areas where they've left trees, where the trees that need to come out. Most of these include utilities that go down those paths, so clearing needed to be done in order to extend the utilities down a path. Those will all be topsoiled and seeded and stabilized.
And maintained by the owner?
And maintained by the property owner, yes.
Halfway, midway.
Midway, yes.
He's gonna love that.
Well, they get open space instead of having pavement next to the house, they have grass. I would be happy to pick up the garbage that's out there rather than have cars driving past.
Brian, technically, for all practical purposes, it's gonna be vacant land, which is gonna be owned by the two properties.
Well, knowing in Lakewood, they'll probably even put their sidewalks, because we've done other developments where there's a right-of-way next to, not the sidewalks, they'll put their fences into the right-of-way, right. And then the township engineer's office, when they go for the COs, is gonna say, they get a survey, they're gonna say your fence is in the wrong place, and it's gonna get moved back.
On the schedule of bulk requirements, on all the plans, it shows the lot width, 75 feet required, and one of the lots.
And that's one of Terry's comments on all of the reports, and I will make sure that FWH understands to do it properly in the future. That normally the way that's done is it has a column up top that says required 75, underneath provided, most of them it's 100, and then it breaks it down below that to show the 50 and 50. But it's done wrong, Terry pointed it out, the applicants know it has to be done before it'll get signed off by the town.
And the future ones, because this was a problem on the previous ones.
Yes, it was.
Let's-
These were already in the works then.
Yeah, I just want to add something else. It's good to have discussion on this, just so the board understands what these applications are. These are administrative minor subdivisions. The purpose of each of these subdivisions is to take one permitted duplex property, a fee simple property, and make it two. You're not approving or not denying the duplex. It's already permitted. It's a permitted use. If it's built per the approved plans, it's allowed. All you're really deciding on, frankly, is whether or not it should stay as one fee simple lot, or should it be two. That's what each of these applications are, nothing more.
Okay, thank you, Terry. Okay, do we have a motion to approve or not approve number 1 through 4? Number 2, Tony? Approve a motion to approve 1 through 4. Second, we have a second? Second, roll call?
Mr. Franklin.
Yes.
Mr. Hibberson.
Yes.
Mr. Flansbrough.
Yes.
Mr. Herzl.
Yes.
Mr. Renner. Mrs. Zagrafos. Mr. Gatoto.
Thank you.
Okay, thank you, Brian. Okay, now we have another ordinances for discussion.
There are two ordinances for discussion. One is amendments to the land development checklist, which is the submission requirement document that I go through when someone hands me an application. Most of those changes are at my recommendation, some are from Grant Siegel, yeah.
Much better.
It's
mean,
And,
there is a technical definition.
exterior hallways.
Each
I
of the
think that's
rooms
other-
have exterior entrances, that's the difference. Correct. Yeah, like I said, I can't remember the last time someone done hotel.
Mr. Renner, I can't hear you.
My only point is that if we feel today that it's a mistake that hotels are in the zone, we should have some shut.
I mean, you may want to consider that separately. I think the recommendation now is simply to include hotels. You may want to look at hotels and see if the town wants to do that in the future, but that should be something.
B5 is only along Route 70 right near the parkway there. And there's a little bit further to the west as well. The southern side is actually B5A. But
Most
yeah,
of the
I don't.
70 corridor looks to be B5.
Really, the question is what zones say that whatever's included in the B5 zone is included in this zone as well. You don't really have.
I think the difference is that this particular interpretation is, do you really need motels, which is the old style where you have exterior doors for each room, or do you need hotels, or do you need both?
Well, I'm sure that the private township adopted this ordinance, and this made this permitted use, they wanted motels and hotels.
Yeah.
But
Whenever that
I
works.
think that today, if we're being asked to reinterpret it, we should really see what is this going to affect, which zones.
You have hotels, when's the last time someone, hotels? In the B5 zone as well.
Where the Hilton Garden is and where the Best Western is. What zones are those? Are those in the
Actually,
B5?
I believe that, no, the Hilton Garden Inn went to planning board. But is that in the LP? Is that on the other side of the parkway? That's the LP. I looked into that and I don't believe it was the same zone. I mean, it's really only a small number of large
I'm about
properties.
70 corridor, and you already have several.
Yeah, but
corridors.
any other zones that say whatever's permitted in the
I
B5 zone.
understand Mr. Renner's point, yeah, because our ordinance does that a lot.
Any
This
zone
zone-
similar to B5,
In terms of motels versus
like,
hotels.
B2, is legal, whatever's illegal in B5?
I can't tell you without looking it up personally. I
can.
know a lot of these zones, for example, if you start with B5 and you go to B5A, very often they'll say everything in the B5 but 1 to 2, and then they add a few. I haven't looked for purposes of.
Wait till the next meeting?
You could make the recommendation that it could be added as a use, but specifically not added as a use in any other zones that reference the B5 use, you know? I mean,
Well, even the B5 comes over Route 70, quite a nice amount, far from Route 70.
yes, it
I
does.
don't want future generations to say why these things. But let's see what we're affecting before we affect.
I want to be here not comfortable, we can get a list of properties at next meeting.
Or that, or we just strictly be fine. And no other zone could,
I made a motion, if anyone wants to second the motion, that we see what streets are being affected.
I'll second that.
Mr. Grunberger.
Yes.
Mr. Franklin.
Yes.
Mr. Hipperson.
Yes.
Mr. Herzl.
yes.
Mr. Renner.
Yes.
Mr. Flansbrough. Mrs. Zagrafos. Mr. Cotillo.
Okay, thank you.
Okay, thank you.
Okay, now we're going to the plan review items.
We have one item under plan review, SP 2214 Torah Tamima of Lakewood. It's a major site plan for a school and a gym. I believe they are here today just for plan review. There is an objecting attorney in the audience as well, and I believe there was a request to not open the public hearing because they haven't had their plan review yet. Mrs. Neary? Yes.
Wednesday, number 7, you want to make one meeting with them?
They had considered, because it's carried a few times, and then, this application was submitted under the old, guidelines, and given that they had carried a few times, if they wanted to do a plan review, they actually would have lost a month, they would have to wait for the March plan review, so they wanted to continue with the plan review. Wouldn't lose time.
You want to talk about waivers, Chairman?
Yes, please.
Yeah, I think everyone on the board has a copy of our February 15th report. It's talking about waivers, we have a couple listed, the EIS and tree protection management. We support waiver of the EIS with the understanding that we be given a copy of the NJDP line, the LOI application, which contains the same information anyway. Secondly, tree protection management for administrative purposes. We recommend waiver with the understanding that if approved, they're gonna have to comply with your compliance.
We have a motion based on the engineer's recommendation. Move for the waivers. Move. Second. Anyone second? Okay. All in favor of the waivers? Aye.
Right, and then under zoning, our interpretation is that parking relief might be necessary. Per our interpretation, they're shown 29 on-street spaces. I'm sorry, that's been upgraded to show 32.
32, right.
Are you still seeking relief on that, or is that compliant?
No, that's compliant now.
Okay, all right. And you've also made adjustments relative to the buffer relief, so perimeter buffers not required?
Correct.
All right, so based upon the changes that you've made, there is no other relief, is that correct?
Correct.
Okay, thank you.
And Mrs. Weinstein?
Good evening. I just want to let the board members know that the reason this was carried so many times is because there is a neighbor who's objecting, who's represented by counsel by Michelle Donato, who's here this evening, together with her client. The applicant has met with the objecting neighbor, and we've attempted to meet all their needs. They're here tonight, I think, with some additional needs, so the applicant is fine if the board wants to hear from objecting counsel, and for them to put their concerns on the record. But our position is that this is a fully conforming application, and we have really attempted to meet the neighbor's needs.
Thank you, Mary. Yes, Michelle Donato on behalf of Mr. and Mrs. Haim Rosenberg. They live at 1677 Hidden Drive, and it's right behind. They abut for 93 feet along the rear line. And you have an ordinance that very liberally allows schools, and we understand that. My clients do not oppose the school, but they want the buffer that your ordinance requires. There are only two things you require for schools. You require parking and you require buffers. And the buffer is not continuous. It is not, doesn't visually screen because the Rosenberg property is elevated higher than this proposed school property. So it's really going to be very detrimental to them. They have a very lovely deck in their rear yard. They just want the berm that the ordinance requires. And we're more than willing to continue to attempt to work with the applicant, but there is a variance here because this buffer is not continuous and it does not provide the visual screen protected by the ordinance. We also have some questions with regard to the proposed dormitory. I know you've got some sensitivity to that based on what we've heard this evening. And we'd like to know how that, that dormitory is going to affect parking and whether that is calculated into the numbers, because you really don't accommodate that in your ordinance. You allow them kind of silently, apparently, I guess yet to be determined. And, we need to clarify, I do not believe that this is going to be for a higher learning. So the question arises as to whether the dormitory aspect is in fact a permitted use. We think there's an excellent solution here, but they do need to comply with the ordinance in order to provide the necessary protection. So very, very few protections that you have, and that one there, we really hope the board will require that it be implied.
Thank you.
Thank you so much.
Just to comment, I mean, we're not really presenting a case because this is actually a technical hearing only, but just to comment on a few of Ms. Donato's points. For starters,
What kind of buffer are you?
well, the ordinance does not require a berm. Ms. Donato is indicating that a berm is required. The ordinance requires a 20-foot buffer. Tom, you want to just come describe the buffer that we are proposing?
Sure.
Here, why don't you take the microphone?
My name is Tom Muller with Dynamic Engineering, professional engineer. So this is just a colored rendering of our site plan that was submitted to the board.
Having trouble seeing you.
Sure. So on this plan, north is to the top of the sheet. The objecting property owner is to the north, to the top of the sheet here. We indicated the 20-foot wide residential buffer along the back of the property with a dimension, and we also show a staggered row of green giant arborvitaes along that buffer, along with a solid 6 foot high vinyl fence.
What's the elevation to the next property? The next property's much higher?
It's roughly the same, it's within about 4 feet, I believe, of our property versus the neighboring property. That's really it. The green giant arborvitaes are very fast growing. They get up to 20 to 30 feet. They grow 2 to 3 feet a year. We're actually planting them taller than what your ordinance requires. Ordinance requires 7 to 8 feet. We're planting them at 8 to 10 feet. So that's actually an additional expense for this applicant that they're doing to address the comments from the neighbor, as well as providing that specific species.
Point out now again where the neighbor property is.
Sure, it's to the top of the sheet. This box here is their dwelling.
Sure, and I need this just accurate, but are you saying that what you're proposing meets the ordinance?
Yeah.
Buffer requirement?
Our interpretation is that we meet the ordinance.
Yeah.
Yes, they are proposing materials. I'm trying to pull up the code, all I can see it unfortunately, my computer's not cooperating. My recollection of the code is that as a rule, you have that 20-foot required, and if you can't meet the 20 feet, the code talks about options that can be done to compensate for the horizontal. It's my understanding you do have the 20 feet. So you have the permitted width, but you're also trying to give a buffer.
Exactly.
And what you're proposing, your understanding, technically exceeds the minimum standards.
Yes, thank you.
Mr. Chairman, may I address that point, because Mr. White did not have the ordinance with him. And there's one standard for synagogues, but another for schools. And I'm quoting from section 906 of your ordinance with regard to schools. And it says that the required buffer shall be landscaped with trees, shrubs, and other suitable plantings for beautification and screening. On those sites where no existing vegetation is present, or or existing vegetation is inadequate to provide screening, the applicant shall, and we all know that's a mandatory word, suitably grade and plant the required buffer area such that this planting shall provide an adequate screen of at least 6 feet in height, so as to continually restrict the view. So that is the section that we are relying on, and
You said it has to be over 20 feet.
yes, in about 10 years. In about 10 years, when at full growth. And they're not properly placed and staggered. I mean, this is the kind of thing that you really shouldn't have to be dealing with. We should just be trying to sit down and make it work out, because that's all we want.
This seems like, we just sit down and follow the ordinance. Can't we just sit down and follow the ordinance?
Well, yeah.
Why do we have to go back and forth?
You heard about a minimum height of 6 feet. Okay, here's a hypothetical.
Of at least, yeah.
So plant 6-foot trees.
They
They're
said
going,
they're planning 8 to
they're
10.
going more than that, Justin.
Right, Justin,
Let me just offer a hypothetical, and again, I'm not playing attorney. I'm simply gonna offer a hypothetical. We heard that the adjoining property is higher than this, okay? What if the adjoining property happens to be 50 feet higher? Do you plant 56-foot high trees? I think you need to apply a standard here. I don't think that there's a simple arithmetic that says, well, I'm here, you must go here. I would recommend you have a month between now and the public hearing, see if you can work it out.
I just want to point out to the board, we have tried to work it out, and we are meeting the ordinance. Tom, can you just tell us, at planting, how tall will the trees be?
8 to 10 feet.
They're gonna be 8 to 10 feet at planting, the ordinance requires 6.
Minimum of
So,
6.
minimum of 6, we are above the minimum, they are gonna grow, Tom, how high are they gonna grow, how much would you say they're gonna
Typically-
grow typically every year?
2 to 3 feet a year.
The applicant has gone to great expense to try to make this neighbor happy. Our position is we're meeting the ordinance. We could sit down with them, but we're not gonna get any further than we got the last few times we sat down with them.
Well, they did go someplace, they just didn't go quite far enough, and I think this can be resolved if the, and I would take up Mr. Voigt's suggestion.
To try before the next meeting.
Thank you very much.
You're welcome.
Thank you.
Okay, do we have a motion to advance it? Ally, where is it going to?
March 21st acceptable for you, Marion?
Sure.
Or is there, I think the plans were pretty substantially complete.
Although,
They
right.
did work on them a lot, so I would say they don't really need to
Yeah,
revise
we
the
don't
plans.
need a full technical review. What I would recommend doing, if you can, if you arrive at an alternate concept, just talking about the buffer. If you can give the board something 10 days prior to hearing, that would be ideal. If you can't, for some reason, bring it to the hearing and we can review it as an exhibit.
Yeah, something like this, that's
Yeah.
very explicit on what's being proposed there.
Sure.
And I just want to mention that I did go with RBG, with Terry's office regarding the left turn in, left turn out. I had some concerns, and the traffic engineer did review the traffic report they submitted, and it did show that even if
It
you
meets
go,
the applicable standard.
way more than that.
Correct.
There should be some type of fence around that drainage, the drainage basin.
Which area are you talking about, John?
The one in the front. All right, let me go back to it. On sheet
I
5.
assume, Miriam, you're not gonna have a problem fencing the basement.
You got kids there.
Right.
The bank's getting muddy, and the kid gets down and they can't get out. I've
Yeah,
had that happen.
that's fine.
I certainly would.
No, that's fine. They're not little kids, though.
Is there a rentable proposal over there?
What?
Is there a rentable place, if there's anything you rented out here for stuff?
No. There's no, hall, if that's what your question is.
Ally, where are we going to? March 21st?
March 21st.
Do we have a motion to table to March 21st? Second. Roll call.
Mr. Grunberger.
Yes.
Mr. Franklin.
Yes.
Mr. Hipperson.
Yes.
Mr. Herzl. Mr. Benner. Mr. Mrs. Zagrafos. And Mr. Cutillo.
Thank you.
Members of the public, please be advised that the application SP 2244
hearing, Chairman, I believe the EIS will have a submission waiver. We had a question regarding existing lots 5 and 6, and existing lot 6 relative to the proper sizing. We'll let Ryan talk about that. There is a design waiver, with respect to, section 18.821 of the UDO, 2 basic house designs for subdivisions consisting of 4 to 6 structures. Ryan, is there any other we need besides those 2 issues?
No.
Thank you. Okay, Ryan?
Actually, good evening. Thank you, Mr. Chairman. Miriam Weinstein on behalf of the applicant Mark Properties LLC. Just to reiterate, yes, this application was modified and it is now a fully conforming application for subdivision approval to create 6 fully conforming single-family lots in the R12 zone. In addition, the applicant is improving 4 paper streets surrounding the subdivision as the board had recommended to us at previous planning board meetings in order to help alleviate some of the congestion in the area. At this point, I would actually ask to have Mr. Flannery sworn.
Do you swear affirm that the testimony you give before this board will be the truth, the whole truth, and nothing but the truth?
I do. Brian Flannery, Jackson, New Jersey, licensed professional engineer and professional planner. I have 2 exhibits. A1 is the map that was submitted. A2 is a map of the area showing the other development in the area. As you can see on A1, the orange outline is the property. We're putting the pink lot lines in to come up with 6 conforming lots. If the board...
Lots 5 and 6.
Lots 5 and 6 are not part of this application? Correct. If the board remembers, this application was part of a bigger application. The applicant had put together more and come in with a plan they thought was better, asking for some variances. At that time, well, it was a bigger application including more properties. At that time, the board said, we really don't want to grant the variances, improve the roads, and come in with conforming lots. So we're back here this evening with a piece of that application, 1 block, that does just that. It's a by right application, not asking for any variances. They're all 12,000 square foot lots. I want to point out on A2, I've done the per cal map in the general area, and you can see that most of the developed lots in that area are less than 12,000 square foot. These 12,000 square foot lots are going to stand out in the area. There's probably in this general vicinity less than 10 existing that conform with the ordinance. The majority don't. I didn't color in the whole map because I didn't have enough blue ink for the Hearthstone area to do the whole map.
Brian, we don't need the Procel map when you're not asking for any variances.
Well, we anticipate that the neighbors who haven't liked anything we've done in this neighborhood aren't going to like this either. And I just wanted to make it perfectly clear to everybody that these lots are conforming, and the only way they're going to be different from the other lots in the area. And Hearthstone's a very nice neighborhood, and it's a nice neighborhood because it's a good place to bring up your kids. It's not a nice neighborhood because everybody conforms with the ordinance, because they don't. They're nice families living in the area, and this will bring more nice families into the area. The prior application also stopped Netherwood so that Netherwood didn't go from Finchley to Cross. This application, per what the board told us, is we're improving the right-of-ways that front our property. And it's not going to be the best from a traffic standpoint for the couple houses that live on Netherwood, because more traffic will go there, but for the general public, it's certainly a better application.
Netherwood is a paper street right now?
Parts of it.
The parts of Netherwood that we're improving around along our frontage is paper. To the north of us, Netherwood is existing. There are a couple lots. You can see on A2, to the north of us, there's 4 lots on the west side and 3 lots on the east side. The lots on the west side, if you look at the areas on the tax map, they look very large, but they have a big wetland area in there. So those lots also width-wise are not conforming. Area-wise, the building area of the lots is roughly around 12,000 square feet also. So the building area-wise will be consistent with what we have. But the lot widths that are being proposed here comply with the ordinance, whereas the existing lots don't.
There will be sidewalks on all the properties.
Yes, there will. And also, I should point out, the map shows Princewood Avenue with the curb going around. Terry's report indicated that we should build the returns and have the hammerhead portion of it in there so that in the future that can be extended. And the applicant certainly agrees to do that in accordance with Terry's report.
Anything else in Terry's report you agree?
We will satisfy all the comments in Terry's report.
Any board members have any questions on the application? Where is this in reference to the last, the one that was memorialized tonight?
The one that was memorialized tonight, if you look at A1, is further south of Elmhurst Boulevard.
And it goes towards Cross Street.
That goes out to
That
Cross
goes out
Street.
to Cross.
Yes.
I have a question about the property that's not part of the application. The applicant owns those properties?
Lot,
The 5 and 6.
No.
lot 5, the applicant does not own. Lot 6, the applicant owns. If you look at the lots that are included, Lot 1 is a Whiting Pines Realty lot, and the other ones are owned by Mark Properties. So Mark's Properties consolidated the lots that are in this application to come up with conforming lots. The 2 lots that are not included in the application would be the subject of a future, but they're existing lots at this time. We're not changing them. What we are doing is putting a road in front of them. Sometimes the applicants try to get cute and stop the improvements where it's not their frontage. That's not the intent here. The road will be improved all the way around.
And
Is there any way to know what's going to be going there?
we don't know, and Lot 5 is owned by a completely unrelated party, nothing to do with this applicant. So we can't tell you. There are no houses on the
No
right?
houses on it,
No
right?
houses.
Right now, it's wooded.
It's wooded.
Yes.
Second, we have to come back to the board, it's undersized lot.
Well, they don't have to. If they merge those two,
If they
The
merge,
ordinance provides for building on existing undersized lots without board approval.
as long as you,
Most likely the goal is to get the other lot under common ownership so they can put one house on
right,
it.
on an
Now, that
8,000
being
square
said,
foot.
You would have to meet the setback.
you'd have to meet the
Yeah, sure.
setbacks.
Absolutely.
So the 4,000 square foot lots,
Would be tough.
they would have to come back to the board to ask for relief. If the 2 lots get put together, it would be an 8,000 square foot lot consistent with the other blue lots on the plan, and a nice house could be built on that and meet all of the setbacks.
And just
But
to-
that's not part of this
That's
application.
not part of this, and even
This a-
if the owners of those lots did try to build on the 4,000 square foot lots, just to clarify, it wouldn't come to this board, it would go to the zoning board. But
Yes.
yeah,
So are you saying that can you build 2 separate houses on those 2 lots?
if you can meet the setbacks or get approval from the zoning board, I'd say it's doubtful that anybody could build any type of a large house on such a small lot. How could you build a duplex? It's R12.
I understand, it's not legal, that's the only thing that would fit. And I'm merging them together.
They couldn't build a duplex without getting a use variance from the zoning board. So,
Right.
without an approval from the without an approval from the zoning board, no. It's possible to build on a 4,000 square foot lot if they can meet all the setbacks, but it's very, very doubtful that that would be feasible.
And it doesn't make the kind of house that exists in Lakewood or would be appropriate in that area. And just so the board and the public understand the chances of getting it approved at the zoning board has had 2 meetings in this year, January and February. And the only thing that was approved in January was 1 duplex on a lot that was 10,300 square feet. And in February, 1 duplex got approved on a lot, again, that was a couple square feet short. So getting a duplex approved on the 8,000 may have
And-
happened 10 years ago.
No,
It's never
better
gonna
yet,
happen
the
again.
zoning board has never approved a duplex in the R12 zone. So the odds of getting a duplex in the R12 zone, I don't think so. As a matter of principle, maybe once. Maybe once.
Everybody's shaking their head.
It's been a long time since,
Brian, he knows.
I think we should leave a recreation area.
I don't know, but,
With so many houses going up over there, we need a recreation area.
Okay.
Is there a possibility of getting Princewood developed? Paved
Princewood? All
on the
to
other side?
Finchley?
Yeah.
There is an availability to do that, and that would be any development to the north of Bellecourt on Block 432. There's no reason for this applicant to do that.
They're taking this in. So who would end up doing that?
The next developer. Every developer that adds on till you finish the whole road.
At the last application, I know that some of the neighbors wanted some sort of like shiny court, like open, close type of.
The application that got denied, yes, that's what the
Well, it was
neighbors.
denied because you were squashing in 20 houses into that one.
We were not exceeding the density that was permitted by the ordinance. They were all 12,000 square foot lots. We asked for lot widths, and part of the lot widths was to save some of the right-of-ways and do more of the paving. And the action of the board was come back with conforming lots and improve the right-of-ways. That's what we've done.
Okay, thank you. Anybody from the public would like to be heard on this application, please come forward. See? Okay, please come forward. Please state your name and address for the record.
Yitzchak Goldsmith, 87 Finchley Boulevard. We're in Netherwoods, Car.
Raise your hand.
Do you swear or affirm that the testimony given before this board will be the truth, the whole truth, and nothing but the truth?
I affirm.
Thank you.
Contrary to what people believe, I don't like being up here every single month, twice a month. I've spent 12 meetings here on this Netherwoods application. They came a couple times to the original one, and they're chopping it up into little pieces. The entire application references, well, we can't give you this because it's dependent on that application. We can't give you that because it's dependent on that application. Why don't we just put it all together and look at the whole development as one, and then see what makes sense from a traffic? They're coming in little pieces saying, this is conforming, this is conforming, this is conforming. And let's look at the big picture and see, does this make sense? And maybe it will make sense, and that's fine. But from a traffic side, it's very hard to do that when they keep isolating and cutting out pieces. I don't know legally, I know Mr. Jackson's very hesitant to use when things get denied, that as long as you change a little bit, you can come back, but it's just very tiring with the neighbors. A lot of people just didn't bother showing up anymore because we've been dealing with this for almost 7-8 months already. And it gets denied, declared, and just, that's what it is. Just throwing that out there. I mean, just in he's saying he's asking for a waiver for the drainage because it's dependent on a different development. And even this, we don't know what the rest of the development's gonna be, so you can't look at it, well, he's gonna come back and do the rest. For all we know, they'll block off Cross and decide to make a cul-de-sac the other way and push all the traffic in through Netherwoods. Until we really see where the whole development as a whole, how do we know where the drainage is gonna be? How do we know what the parking flow is gonna be? Maybe he'll come back for a cul-de-sac the opposite way and cross out Cross and then put all the traffic up through Finchley. We have no idea what's gonna happen.
I don't think he has to develop the rest of the property.
He doesn't. That's the point. But that's the point.
He's not asking for any variances.
I get that. I agree 100%. It's a conforming application and regarding this specific piece. But the point is, we don't know.
If he does another piece, he has to come back to the board.
I understand, but we can't look at, it's very hard to see in isolation what the effects will be of the neighborhood, and that's, he asked for a waiver because he's dependent on a different application, so he does link. He's asking in review number, comment number, sorry. 11, yeah. Correct, number 11, the drainage plan. Drainage plan needs to be completed and coordinated with other improvements in adjoining projects.
That's not a waiver, we're simply.
It's not a waiver, but how do we know what's going on unless?
What typically happens when an application gets here. In a perfect world, we want it to be as close to 100% complete as we can. Most applications are not, even if you do 10 weeks. Not just Lakewood, everywhere. So we get to a point where we look at an application and is the design viable? In this case, the answer is yes. There's still work that has to be done. There are legal requirements. They have to comply with what's known as the New Jersey Stormwater Rule, as does all major development in New Jersey. If the board acts favorably, this process goes into what's known as a compliance period, where we will review this plan very possibly several times past this hearing, and to make sure it's fully conforming with all the design standards,
So we'd wait till you got all the rest of the pieces. I understand.
No, I don't think that's what it means. No, it means that the drainage plan must be completed. In other words, before you build, there has to be a completed drainage plan.
And that's perfected in.
Okay, that's fine.
I think that's just that's a misunderstanding. The drainage plan needs to be completed. It's not
When you
waiting to
have
be
a
completed
drainage
until
plan,
other
additional work needs to be done, which is common for most applicants.
You cannot get a CO until it's totally accepted by the.
Gotcha. And regarding putting up Princewood, there really isn't any, the township owns that whole piece of land pretty much from Princewood up to Finchley that's not improved. So it really fall on the township to do that, which probably will never happen. So from a traffic congestion standpoint, it probably won't be open unless the applicant, you're talking 100-something feet, maybe 120 feet. We're not talking a big scheme of things for the builder. Once he's doing the whole thing, to wait for the township to do that would be a very big, deal, but I'm just, there's no other property that's really gonna end up having to do that. And just the third piece of information I wanted to point out was, he is asking for a, architectural waiver, or is that not considered a waiver? He needs to submit the architectural plans as well.
How does the applicant want to handle that, Ryan?
Before the applicant comes in with plot plans, when he knows what houses he's building, he'll give you the architectural plans. To give you the architectural plans at this time would be an exercise in silliness, because he doesn't know what houses he's building. Clearly, we're gonna have two different house plans on this. These are gonna be beautiful lots in a beautiful neighborhood, and it's a ordinance requirement that the applicant will comply with. He's just not providing it now because it doesn't make any sense.
Maybe I can just clarify that. It's very typical for when you get a subdivision approved, they have what's called a building envelope. So you max out the building envelope, and then when you're actually ready to build houses, okay, you're in, and we'll plot plans approved, that's when you start architecture.
Correct, but the problem is it won't come back before a board where you have public input.
No, that doesn't, well,
And the builder here, and is knowing a lot of builders, they pull shenanigans with attic apartments, base double this, that. So they try to bypass this step where it's scrutinized by the board and the public, and they'll get it in later with the building department, however they manage to get it in. But no, you're required to have it here. But he's asking to bypass here and then go through. Right, once it's out of your hands, that's the whole point. He wants you not to have your input and the public's input. As you just mentioned, once it goes to the building department, no one's gonna ever know what happens, and it's just gonna slip right in. So that's why I do believe it is important to have it done on the map, because the builders do abuse. They put side staircases that go up to the attic and stuff like that.
The ordinance requires that you have two building types. I think you're hearing two separate things. Even if the board had plans tonight that said this is architecture A, architecture B, the board is not reviewing this submission with respect to compliance with building code standards. That's not the purview of this board. The purview of this board is to review land development applications. Subdivision. Yeah.
The zoning board's
Hearing
different?
What the applicant is saying is they intend to comply at plot. They're not complying at this time. They could very easily give you two different sets of architecture and then build two other types of architecture later. But the question regarding what happens at building code about attic spaces, whatever, that's not something that the board typically handles.
That is a big discussion at the cabinet committee level requiring an architectural.
It's on the checklist.
But that's not for today.
Going forward, we will get.
They're required for, right now they are required for site plans. We are adding them in as a requirement for major subdivisions. Right now, the code requires that the applicant provide for at least two basic house designs for a major subdivision, but the checklist requirement doesn't actually say that architectural is required. So we are fixing that with the proposed one.
So in the future, architecture will be required from a completeness standpoint. Just understand that even if you have architecture plans in front of you, they may not be the ones that ultimately get submitted with them.
Unless somehow the board can condition their
Right.
requirement on exactly those architectural.
Well, the zoning does that, where you can't put stairs.
Require those specific plans with, however,
Oftentimes they do, yes.
bricks they want in front.
Yes.
The zoning board, I can tell you because I handle both things. The zoning board often looks at infill development. They'll have single properties. They'll have minor subs, major subs. There is a standard zoning requirement if you look at a zoning board resolution. The zoning board tells applicants, we want to
side be 1/3 brick or stone. That's a common complaint. Now, the zoning board being the Board of Adjustment, they have latitude because the people coming in front of them need to have zoning relief. So if you want to have the applicant say, are you willing to do what's done with zoning board, you can certainly ask the question. But this is a conforming application, to the best of my knowledge.
Thank you. Anybody else would like to be heard? Please state your name.
Shlomo Klein.
Raise your hand, sir. Do you swear or affirm that the testimony you give before this
I
board will be
affirm.
the truth, the whole truth, and nothing but the truth?
I affirm. This timer is bothering me. No, it's not. Technically, it shouldn't be timed by the public, by public comments on the application, and plus when you could ask questions.
Sir, it's in the board's discretion.
What?
It's in the board's discretion. How
We had a discussion with John Jackson, emails back and forth. My understanding was that no timer will, or the timer will only be implemented by the public portion, but not by the portion where the applicant, you have a right to cross. You cannot, the problem is like this. If an attorney would have stand up over here, you would have given more time. And when the law states that the public has a right to comment and cross-examine, it says attorney or members of the public. So you have to give the discretion both the same rules. You can't just give attorneys different rules than members of the public. And the fact is, if this would have had a member of the public standing up and the attorney standing up and speaking, you wouldn't have put on the timer.
Mr. Klein, we certainly have not cut anyone off or asked them to stop speaking. It's merely a guide and a reminder that we do have a lot of things to get through, and it's just a general guide for timing the public. I mean, if you were to continue speaking after the timer goes off, no one's going to escort you from this.
But I'm asking, when attorneys speak, you also put on the timer to intimidate them and show the discretion that, hey, you have to stop while the timer is off. But just do the same thing. Just give us the same treatment. Thank you.
You have anything on this application?
Actually, yes. Last time I came up over here and I asked the applicant, it was the Oak Street corridor application, and there was missing a sidewalk. And I asked him, yes, you got away with sidewalks and all that, calling it access easement, and he was willing to put in sidewalks. He was very nice about it. He did it already in the previous time when we asked him to put in a bus shelter. He put in a bus shelter. Now, this application comes in, it's putting more houses. In other words, the people will come in and go out just from this access to Hartstone, and it will make it very hard for this application. That's the reason why these people came and objected to the applications the previous time. Now, when you have over here on Princewood, there's just 100 feet about that is missing a road. I would ask the applicant if he's willing just to show has nothing to do with variances or waivers, if he's willing to just improve that road, and that makes it easier for everybody, including for the Hartstone guys to go out and in, including from this neighborhood, not to put everything on Edwards Drive.
He's not building there.
No, he is building over here. Over here he's building, and this road over here is connecting, and over here the road is, Princewood is connected, so it's just missing this part.
Why should that applicant be responsible for this?
He's not responsible. I'm not asking you. I'm just saying is if he's showing goodwill, and as somebody of the member of the public came up over here and accused him from being such a bad builder, and we had experience over here in the board in the past that he was willing to go out of his way to improve stuff even though he's not required to, because we came up and asked for it. The question is if he's willing to give the same treatment over here on this application and make everybody happy, and like this, if he improves that 100 feet of roadway and put in the sidewalks and everything, it will make it much easier. But, do you want to ask your applicant if he's willing to do it?
I don't want to ask. First of all, he's saying it'll make everybody happy. It won't make everybody happy. It'll make some people unhappy. Secondly, if you look on Google Earth, you can see that the corner property where we're talking about, there's trees there. You see those trees there? Those trees aren't going to stay there. They're on somebody else's property. Somebody's going to build a house on the corner, and when they build that house on the corner, they're going to build that 100 feet of road that connects it up. So this applicant, it's not his responsibility. He's providing RSIS compliant roads. He's building single loaded roads all around his property. So the answer is, No, it's not gonna make everybody happy. No, he's not volunteering to do it. He's doing what's fair. He came back and he did what the board asked him.
Thank you. Anybody else in the public like to be heard on this application? Please come forward. Mr. Holliday.
Do you swear or affirm that the testimony given before this board will be the truth, the whole truth, and nothing but the truth?
I do. William
State your
Hobday,
name and address.
William Hobday, 30 Schoolhouse Lane, Lakewood, New Jersey. The question, is this plan complete?
Yes.
I just noticed item 8, the review comments, says the grading plan and profile street provided are incomplete. These plans shall be completed and coordinated. We are at the public hearing. Has that been completed?
To answer your question, Mr. Hopday, they've been revised subsequent to the initial review comment. If you look at what is in bold, it refers to the review of the revised submission. They have made improvements. There's more improvements to be made. They are complete. They're not 100% technical. They're not 100% technically adequate. It's certainly feasible. Again, if the board acts favorably, making 100% is typically done at the compliance phase. But for hearing purposes, the plans are complete.
Okay, thank you.
You believe that, does the board believe that there is complete, even though it says it is not?
Yes.
Being the author of the review, I can tell you what the intent of the comment is.
Okay, I would revise my statements and
If the plans
and say
were-
it's,
I can understand how it appears. The way that we review these, again, this has gone through 2 technical reviews. The initial comments are what is not bold, the revised comments are bold. They have made revisions, as is very common for most major subdivisions and site plans. They're not 100% perfect at time of the hearing. They are complete, more work is necessary. If the board acts favorably, that would be done in compliance.
my only suggestion then was add that commentary to the review comments so someone reading this would know what you're saying. You know, it's complete, it's not complete, but it's kind of complete.
We understand the comment, and we'll try to be clear.
Thank you.
Thank you, sir. Okay, thank you, Mr. Holliday. Anybody else from the public like to be heard on this application? Please come forward. Please state your name for the record. Mr. Mayfield.
Ellie Bacharach.
Raise your right hand, please. Do you swear or affirm that the testimony given before this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, just to go back to the point of opening up 1023 Netherwood Drive. Just to go back to the point again about opening that small strip of land, and also going back to the point about this application coming up in piecemeal. We know that this whole area, I'm just trying to get oriented with this map, this whole area going down to Cross, there are 4 blocks that are going to be developed by this builder. Right now, he's coming in with one of those blocks. He's going to be putting in 3 times more the amount of houses in this area. When he comes back for these applications in the future, knowing that there's going to be such a strain and so much, all the traffic from Route 9 and from Cross is going to be coming through Netherwood, which is a narrow street, could the board obligate him to open up that strip of land on Princewood? To open up more arteries so that it'll alleviate the traffic, and really it makes a lot more sense for Hartstone to have those streets open. If you look at Princewood, that's the street that goes all the way through. It intersects from Cross, and it goes, the paper road is on Cross, and then it goes up all the way through Hartstone. So now if they go through Netherwood, you have to go up Netherwood, you have to make a left on Finchley, and then go through the heart of Hartstone.
Mr. Flannery, want to answer?
Well, we're talking about this application, and that was answered on this application. A future application that comes in, if somebody asks for some onerous variances, well, then maybe the board can say, you know, you're asking for something, do something so that the benefits outweigh the detriment. But it's really inappropriate to be talking about a future application when we have a conforming 6-lot application.
But those applications have come in front of the board over the past few months, and we've been out here the past few months. We know that what's in the works. And my request is to obligate them to open up that street, knowing that these applications are going to be coming down in the future. So why is he coming in with piecemeal applications now?
He's not required to build anything, he leaves vacant land there.
Sir, the board has heard your request.
When he came in front of the board and wanted to develop the whole neighborhood, all the neighbors came out to oppose it. At that time, was it gonna be open, the streets? Was it ever proposed to be open?
Let me just answer the question. Just actually to sum up from what all the neighbors are saying, I just want to remind the board that it's actually, first they keep referring to the builder. There are actually various applicants here, not just the builder, but the various owners of the properties got together and they brought one application that was going to encompass the whole area. If I may just remind the board that these very same neighbors all came out and objected to it, which is the reason that the board elected to vote it down. Now they're coming back and they're saying, why don't we come back as one big application? Well, there's a very simple answer, because the board voted it down based on the comments that these very same neighbors made. At that time, the board felt, the neighbors all came back and said, we don't want you to open up the roads. And as Mr. Grunberger reminded everybody, they said, we want there to be, you should close it off, kind of like Shawnee Court was. The board did not like that idea. The board said this area is very congested, and from a planning perspective, it's actually a better approach to open up the roads. Now the applicant, it's various different applicants that own the different pieces. They're coming back with each one piecemeal, opening up all the roads and doing exactly what the board is saying, and giving fully conforming applications, which actually means lot sizes that, if you look at the per-cal map as we did before, are actually significantly larger than almost all of the lots in the Hearthstone area. So just to point this all out, again, this is a fully conforming application. The board doesn't really even have grounds to vote against it. We're just really spending a lot of time going back and forth and reiterating everything that we've done on the last 4 applications.
I just wanted to make you feel better. I know that it wasn't going to be open in the first one.
No, the original application was no, because we were working with the neighbors to try to make the neighbors happy, but the board didn't like it.
Please be quiet indoor meetings. Okay, thank you very much, Ms. Weinstein.
You're welcome.
See no one come forward, we'll close it to the public. We have a motion for this application.
I make a motion to approve the application.
Okay, we have a second. Do I have a second? Service and second. Okay, roll call please.
Mr. Grunberger.
I'm gonna abstain.
I'm sorry, I couldn't hear
I'm
you.
gonna abstain.
You understand?
Thank you. Mr. Franklin.
Yes.
Mr. Hipperson.
Yes.
Mr. Herzl.
Yes.
Mr. Renner.
Yes.
Mr. Flansbrough. Mrs. Zagrafos. Mr. Patillo.
Thank you.
Next, application SP 2207 by 36 Airport Road LLC. This is a major site plan for an addition to an existing office building on Airport Road.
As indicated in our February 15th letter, Chairman, under waivers, there was one that was granted at the January 3rd workshop. In terms of zoning, there is very truly necessary for lot area, as well as sign area, and also under design waivers, there's design waivers for providing sidewalk along private frontage, as well as shade tree and utility easement along the Airport Road project frontage. We'll let the applicant testify as to.
Good evening. Miriam Weinstein on behalf of the applicant, 36 Airport Road LLC. This application, just to remind the board members, you did hear this one, a technical hearing. This application is for preliminary and final major site plan approval for a proposed addition to an existing office building in 2 phases. And just to remind you, this site currently houses 2 office buildings. The first is an older, roughly 6,000 square foot, 1-story office building. The second is a newly completed single-story office building that was approved by this board not too long ago. As a result of a need for more office space, the applicant proposes initially to construct a 2nd-story addition to the newer building. Then, at a later date, the 2nd phase would, I know.
Chairman, ask him to go
Please
outside.
take your conversation outside.
So yeah, we're getting there. But let me just want to make sure you understand what's going on. Then at a later date, the second phase is going to consist of demolishing the smaller building, which is known as 40 Airport Road, and then constructing a 3-story building above a parking area that's going to ultimately be connected to the first building. And all of the site work associated with this project will be constructed as part of the second phase of the project. There are actually 2 variances. The first variance is for undersized lot. The variance for undersized lot is an existing condition that was actually created by a previous right-of-way taking when they made that entrance to the parkway. At that point, they took away 12.23 feet, which resulted in a lot size of 2.91 acres, where 3 acres is required. This variance was actually already granted whenever it was about 2 years ago. And you granted it. The second one is actually for signage. The signage variance is for 114 square feet, where 75 feet is permitted, which I will, at this point, I guess I would ask to have our engineer and planner, Graham McFarland, sworn, and he can give the testimony.
I do. Graham McFarland, professional engineer, professional planner with BDS. Yes, as discussed, 2 variances, one for the existing lot area, de minimis. 2 is for the area of the proposed sign located in front of the building. You can see it on the architectural rendering. The sign has a total area of about 15 feet in width and 9 feet in height. The total area, I think, of 114 square feet, where 75 is the maximum permitted. We believe it's appropriate scale and size for the building proposed.
All the buildings have the same size sign?
Yes, it's a monument sign. You can see it would only be 9 feet in height, basically, a ground level type sign. Again, we believe it's consistent with the zone and provides for adequate identification of the building, and it adds to the appearance of the building.
And parking, you have
Parking, we have parking in excess of ordinance requirements. At full build-out, we'll have 174 parking spaces, which provides a little higher ratio than is required by ordinance. As Miriam discussed, we are seeking the approval in 2 phases. Those phase plans were submitted with the package that the board has. Each phase will have enough parking for that phase to stand on its own. So for phase 1, we'll have 107 parking spaces where 90 are required. Again, in phase 2, we're not asking for any variance.
on the parking.
Correct. We comply, phase 1 independently, and we comply when the project is built out in total.
Thank you. Any board members have any questions on this application?
Can I just raise one issue?
Yes, sure.
The only issue, Terry, you had a comment in your report asking for the lots to be consolidated. I just want to clarify that at the moment, this is actually a condominium because there are actually 2 office buildings that are sharing a single lot. The applicant does agree to the lot consolidation, but we're not going to do that until the 40 Airport is demolished. They right now have separate loans on each building, and it's not going to make any sense to consolidate those lots until such time as 40 Airport, the building at 40 Airport is demolished.
So if the board acts favorably, you can condition in the resolution that it will be consolidated at time of.
At time of demolition of the building at 40 Airport.
It's 2 separate owners right now?
It is actually.
You have an easement to...
Well, there's a condominium that was set up, because there's all the common areas that are shared by both. But each of the units each building is actually owned in separate ownership, so it wouldn't make sense to consolidate them until that building's demolished, and then they will be owned in common ownership. Basically, I'd say at phase 2, it will be.
The demolition's not part of this application.
It's part of phase 2. It is phase 2.
We have a question, what about the sidewalks?
We don't have any sidewalk proposed along the site frontage. There's no other sidewalk within the industrial park. That waiver was granted at the original application also.
I think we're not trying to encourage pedestrians to walk through the industrial park, and that's the reason. That's the one part of town that we typically don't put sidewalks. No.
No. No. I think we actually received correspondence last year about that, where we had reached out to the industrial park and asked if
Right.
they were interested in having sidewalk, and they said no.
Right.
Okay, thank you. Anybody in the public want to refer this application, please come forward. Small minutes for all applications.
No,
Sir, raise your right hand, please. Do you swear or affirm that the testimony you give before this board will be the truth, the whole truth, and nothing but the truth?
I affirm. About the clock again.
Please state your name for the record.
By the clock, it's going down. And by the last application, the attorney, the member of the public was repetitive, and the attorneys told him, okay, we got your point. Can't have it both ways. If it's 4 minutes and you give somebody 4 minutes, let him be repetitive. If you don't do the 4 minutes, we understand he shouldn't be repetitive, but you can't do it both ways. So again, respectfully, again, I ask, this clock is intimidating, and please. About the sidewalks, how close is this to Route 70? This, you don't know? Like,
Route 70, it's not very close to Route 70.
like a few buildings
It's,
down?
It's very close to Cedar Bridge. It's one lot from Cedar Bridge, so it's really,
Do you know where the entrance is to
Not
the
close to Route
Parkway on
70.
Airport Road? It's adjacent to that.
Okay, so we know that there's a few CAFR permits for residential units, and one is LIC, but we know there's a few coming up in CAFR. Next to that, there's a different zone that townhomes and duplex are permitted. In hundreds of housing is going to be built. Now, the township ordinance doesn't make a difference between industrial park and Route 9 and County Line. You always need sidewalks. So to this planning board to come and say, hey, township committee, every time there's going to come an applicant on Airport Road, an industrial park, we are going to waive them the sidewalks, that's what you're keeping on doing, then go back to the township committee and let them change their zone. They didn't change their zone. They didn't change what is requirement for sidewalks to be put in. They understood that it should be done in an industrial park. Could be their envision, Mayor Lichtenstein might think is, eventually we'll put housing in industrial park. That's the reason why he wants it.
The industrial commission has requested that we don't put sidewalks.
Yeah, I can speak on that, industrial commission. It was specifically stated by the industrial commission that they're discouraging sidewalks within the industrial park. Like Mrs. Weinstein was saying, discourage pedestrian traffic. There are schools in the industrial park, as we all know, and they don't want to encourage the school children and everybody else that's inside the industrial park to be walking all over the place. They want them to be contained within certain areas. If you have a school in the industrial park, you want the children to be contained within the school property, not to be walking on the sidewalks. And actually, from my recollection, there are actually some businesses in the industrial park that said we do not want sidewalks in the industrial park. So it came from both the commission's perspective, but also from the business perspective in the industrial park.
So why was the zone not changed?
I don't know, it's a good question.
You see, you could have the industrial commission looking out for the industrial. The township committee is their requirement to look out for everybody. They understood in the future down the road, there's going to be people walking there and sidewalks is necessary. That's the reason why they didn't change the zone. By you encouraging, it's not considered safety, for the fact is that you see now there's applicants coming up over there and asking for residential, and they're going to get it. There's a high demand for residential. So I beg you not to give waivers of sidewalks, even in industrial park, because eventually down the road, when you guys won't be sitting there, you will be out, going with a cane, and things will happen, and we'll say is, oh, once upon a time there was Justin recommending no sidewalks being put in. But please, Lakewood is changing, and one day we'll get rid of the Lakewood Industrial Commission. So please, don't give a waiver for sidewalks.
Thank you. Anybody else from the public would like to be heard on this application? See no one come forward, ask for a motion. Approve, do we have a second? Second. Second from Mr. Feinstein. Roll call, please.
Mr. Grunberger.
Yes.
Mr. Franklin.
Yes.
Mr. Hipperson.
Yes.
Mr. Herzl.
Yes.
Mr. Flansbrough.
Yes.
Mrs. DeGrafo. Mr. Patillo.
Thank you.
Motion approved. Number 3.
Next application is SB 2213 for Congregation Newstead. It's a major site plan for a house of worship on East County Line Road.
Mr. Chairman, Mr. Chairman, Mr. Chairman.
Everybody, please be quiet. Not here.
Or step out, or I'm going off the record. I'm not going to deal with this.
Make all your conversations outside, please.
setback, combined side yard setback, off-street parking, and the parking proposed, which is within 5 feet of the side property line, which is also a variance condition. In addition, the applicant requires relief with respect to further I believe that's everything.
Thank you. Mr. Brown.
Members of the board, Samuel Brown appearing on behalf of the applicant. It's important for the board to understand the nature of this particular congregation in that it serves a community that is, for the most part, walking to services. The services are not, as you might be familiar in some other places, where they're going on throughout the day. There's morning services, which takes place once before businesses are generally open. There's evening services, and then the afternoon services depending on the timing, as most of you are probably familiar with. The very short and simple application is the fact that this is a place which is in great need. The improvements that are being proposed are warranted under the circumstances. There's nothing about this application that should surprise or upset any of you, and if you have any questions, I'm going to turn it over to Brian Flannery for purposes of efficiency.
I do. Brian Flannery, Jackson, New Jersey, licensed professional engineer and professional planner. I have 4 exhibits. A1 is the a rendered version of the site plan showing the building with the parking in front of it off of County Line Road. A2 is the building that's going to be constructed there, and you know, it's obvious the applicant is intending to put a beautiful structure there for an inherently beneficial use. I also have in front A3 and A4, which is an aerial showing where the site is, and A4 is an aerial with a circle indicating the residents in the area. It's got a quarter-mile radius and a half-mile radius, and as Sam pointed out, this is for more of a neighborhood use. That shows the neighborhood. Within the quarter-mile circle, there's 918 families. Within the half-mile, there's over 3,000 families. So it's people that can walk there. We all heard what County Line Road is at the last meeting when there was that recommendation needed from the board. Right, and it's easier to walk than to get in your car and deal with the traffic. As Sam indicated, it's a morning and evening. It's not an all-day. It's not a minion factory.
I wasn't going to use that terminology, but I guess.
This is something that's needed for the area, and it makes sense. We are asking for some variances relating to it, and it's my opinion these are all variances that certainly the benefits outweigh the detriments. This is in the B4 zone, which for business uses, and the ordinance differentiates between residential and business. A house of worship, if it wasn't put there, a business could be put there, and businesses can be put a lot closer to the property lines than a residence or a house of worship. We're asking for the first variance in Terry's report is minimum lot area. 20,000 square feet is a B4 requirement. This is an existing lot of 10,966 square feet after dedication. It's a 12,460 square foot lot. The applicant is dedicating some right-of-way so that County Line Road can be wider, which is a benefit to the public. 3, variance for minimum lot width. Again, it's an existing lot. The ordinance requires 100. 74 is what's there now. After the dedication, or if you measure at the future setback line based on the dedication, it's 70 feet. Minimum rear yard setback, we're asking for 5 feet. The ordinance is contradictory here to some extent. The ordinance itself says 30 feet, but there's a chart in the back that says 10. So we're asking for 5, and I think if you look at the use, it's appropriate. Variance requested for minimum side yard setback, we're asking for 5 instead of 10. combined side yard setback, we're asking for 10.1 instead of 20. The number of parking spaces, the applicant was originally looking for a kiddish hall where we would need parking demand, and they were looking for an off-site parking facility to accommodate that. They have not found that, so at this point, the basement would only be used on Shabbos or holidays where there's no driving, so that we don't have any parking demand for that. The parking demand for the shul itself is 6, and we're providing 7. So,
You agree to no outside, until we get more parking, no outside
Correct.
catering, no outside,
No catering for outside simchas, outside events of any sort. It's specifically for the use of the congregants of the shul, and to be specific, it is intended to be used for holidays and weekends. It's not intended to be used during the week. It was actually explained to me that even midweek events that would take place at the congregation with the congregants would be in the sanctuary, not in the simcha hall.
so technically, until we get more parking, this will be restricted, that it cannot have anything else in the middle of the week. Any
well,
outside-
we would agree to a condition that would limit that. The applicant certainly would prefer not to have a deed restriction, because lifting the deed restriction in the future, if parking becomes available, is onerous.
And again, just to make it somewhat clear, there is a deal in the works. I would rather not confuse the board with the deal, and instead, for the benefit of your professionals, we are more than happy to allow a condition of this approval, be that this not be used for any outside events, and that it be restricted for weekends and holidays when the congregation is together.
We also need a variance for parking within 5 feet of the property line, and perimeter buffer relief of 10 feet where 20 feet is required. And again, these are variances that the benefits definitely outweigh the detriments. If you look at the master plan of 2007, on page 39, under houses of worship, it indicates there's an acute need for sites for neighborhood synagogues based on the explosive growth, and the conclusion is the need's only been partially met, and I think we all know that. This is in the downtown regional center, so when you look at some of the variance relief that we're asking, if you were in an area, Hartstone or somewhere else where you're on, not in the downtown regional center, someplace of a different dynamic, maybe these variances wouldn't make sense. But in the downtown regional center, it indicates, that's the historic heart of the township. It contains a identifiable commercial district surrounded by high to moderate density neighborhood, residential neighborhoods. And the vision is for a diversity of services, retail shops and restaurants, and certainly a shul is part of that services that's required. The master plan of 2007 says encourage development and redevelopment based on smart growth planning principles, and this accomplishes that. The municipal land use law, under the purpose of the act, encourage municipal action to guide the appropriate use or development of all lands in the state in a manner which will promote public health, safety, morals, and general welfare. And this clearly promotes the general welfare.
There's sidewalks over there?
There are sidewalks. There'll be sidewalk along the frontage, and we will comply with the comments in Terry's report. With respect to one of his comments was testimony on the trash, we would meet with Public Works. Whatever Public Works says we need to do, we would do. If we can't accommodate what Public Works needs, then we would have to get a private hauler.
That's changing, right? That has to be Public Works first.
Not that they need to meet Public Works, but that they need to get Public Works feedback. Now, with the initial application, just the same way that I send a copy of the plan to the fire commissioner, shade tree, and environmental, I'm going to send that.
So these are certainly variances that can be granted without any detriment to the zone plan and zoning ordinance, and the benefits clearly outweigh any detriment.
Now again, just for the board's edification, there are large number of people who are here in support of this application. I'm not going to have each person come up and tell you that the timer is running too quickly or too slowly and that they want to, make a lot of points to the board. I'd like to keep this as efficient as possible, and I just want to point out that the room is pretty much full with supporters of this application. In addition, the applicant has discussed this application and all of its specifics with the immediate neighbors, and they're all in support of it. I don't know if they're all here, but they're in support of this application. It's something that adds a benefit. It's something that's badly needed, and it's something that doesn't in any way harm the surrounding area. To the contrary, since it's more of a pedestrian site, and it's a site that doesn't even make sense to drive to. It's not like I want to drive to this place because I'm going to find parking, because there is no parking. There are a few spots for reasons of their absolute necessity, but that's not what's going to service this congregation. This congregation is going to work because there are thousands of people, 3,000 and such, within a half a mile who can walk to this place and can use it. It's a place that's badly needed, and this application accordingly should be approved.
I think anybody in that area is much quicker to walk.
Of course. Yeah, of course. But the board does have to weigh the veracity of our representations that this is a place that is going to be serviced by, the number 11, my mom used to call it. People are going to walk to the shul, to the congregation, rather than use a vehicle or some other form of transportation.
Basically, all the congregants over here live within walking distance.
I was told to point out to the board that there are some folks in the congregation who are not necessarily old men, but who don't drive. It's part of the nature of this congregation. It's to keep things simple. It's to keep things. I don't want to use the word old-fashioned or primitive, but I will use the word simple, because that's really the style of what's trying to be done here. Is the style of the congregation and many of the congregants, and they would like to keep it that way. So I look for the board's support.
Anyone have any questions for this application?
Yeah, I have a question. On the plan, it shows that the lot area that you require 10,000 square feet. I'm just confused because I heard that you require 20,000, but it says 10,000 on the plan.
Well, there are some inconsistencies in the ordinance. The most restrictive number is the 20,000, which we've indicated that we're asking for the variance relief from. But
on the table, it says required 10,000.
yes, and that was when FWH did the plans initially. They went with the number that was they felt appropriate interpretation of the ordinance. Terry's office has pointed out that the body of the ordinance under that section of the zoning section in chapter 9 says 20,000. So we're asking for 20,000. The table in the back has a different number.
According to the table, you don't need a variance.
Correct.
Yep.
If I can add something, Chairman, we've had discussions with the zoning officer where this has come up on other applications where the ordinance may say X and the table in the back may say Y. The zoning board officer, when that happens, she interprets that the text of the zone is correct.
When the ordinance is updated, to my knowledge, nobody updates that chart, so that chart's not reliable.
And I don't like to deal in hypotheticals, but the point of Brian's testimony is that in the event that we need relief from a 20,000 square foot lot requirement, we're requesting that relief. It's perfectly appropriate, and all of the factors are met. Thank you, Terry.
Anybody from the public would like to be heard on this application, please come forward.
I affirm. I just want to let the members of the public know that this clock is timing down. It's illegal. And the law in the MLU states like this: as long as if you are repetitive, that you make your point and you're repetitive, the chairman has discretion to shut you down. Not the attorney, the chairman. So know your place, attorney. You cannot shut down the public. You have to let the chairman do his job. I know he's in training, but he's getting better. I have 4 minutes now. Okay.
We're going to deal with this if it's legal.
Okay. And just want to let the members of the public, if you're repetitive, then he could shut you down. If you're not repetitive and you go over the 4 minutes, you have the right to speak as long as you want. Thank you.
Thank you very much.
Was that in support? I'm sorry. Was that in
support
I give
of
him
the
my
application?
agreement.
Okay.
Should you swear or affirm that the testimony given before this board will be the truth, the whole truth, and nothing but the truth?
I do. William Hobday, 30 Schoolhouse Lane. And the only comment is on all of the zoning issues, it's not 1, 2, 3, 4, it's a whole plethora of zoning problems. I asked you to look at that strongly because we're getting into so many requests for variances that if it was 1 or 2, it wouldn't matter much. But this is so many that is compromising everything. And maybe the neighbors are in favor of this, but it's going to compromise their property too. What I ask you to look at is all the zoning issues in here that together, collectively, make this a difficult situation at best, especially for the neighbors. Thank you. The only other one to comment about Mr. Brown, old men do drive because sometimes we can't walk so well, so we have to.
Thank you. Please state your name for the record and give me your.
Do you
Yeah, I
swear
do.
or affirm that the testimony given before this board will be the truth, the whole truth, and nothing but the truth?
Yes, yeah, I do.
State your name and address for the record, sir.
Joe Leibowitz, 210 East County Line. I just want to remind you, Mr. Chairman, Leibowitz. Joe, you said by the last meeting that parking variances, we should be very strict and we should not grant parking variances so easy. The chairman said by the last meeting that parking variances, we should be strict and we should not grant parking variances. I don't know if there's a parking variance enough. I don't mind the setback about the parking variances. There's gonna be a coil up there, so obviously a million is more than 10 people. So I just want to remind you your words, which you said at the last meeting. Thank you.
Just have a question. If you take away, if they're not doing the catering, do they need a parking variance?
Technically not. According to the square footage, they do not need a parking variance. And they're restricting it, that they will not use it only on the weekends, when nobody comes to work.
Do you want to clarify that, Brian?
Is the public closed?
Do you comply with parking?
You want to close the public?
Yeah, anybody else in the public would like to be heard? Seeing no one come forward, I will close it to the public. Brian, please.
We are not asking for a parking variance. We submitted with the need for a parking variance. We've changed the application, withdrawn the hall, so we no longer need parking for that. We comply with the parking required per the ordinance for the shul. And Mr. Hobday asked you to look at the scope of the variances. We're asking you to look at this application. Yes, and see that, my opinion, and I think when you have one resident from the Fairways who comes out, a lot of people have been noticed here. We have a lot of people out in favor of it, nobody out opposed to it. One neighbor who wants to make sure we don't get a parking variance, which we don't. I think that explains it.
Thank you.
About how many people come to Darwin in the shul?
There are currently under 20 people who come on a regular basis. And there, as was indicated earlier, these are people who walk.
I have a motion. Second. No, somebody made a motion. You made a motion? We have a motion and a second. We're adding to the motion that we only use on the weekend, that we shouldn't have a parking variance.
Mr. Chairman, if I may, please be clear that we're talking about the Simcha Hall downstairs. Will not be used for outside events and will be used internally for the weekends. That would be perfectly appropriate to add.
So do we have a roll call?
Mr. Grunberger.
Yes.
Mr. Franklin.
Yes.
Mr. Hipperson.
Yes.
Mr. Herzl.
Yes.
Mr. Flansbrough.
Yes.
Mrs. DeGraffos. Mr. Contillo.
Thank you, members of the board.
Thank you.
variance, side yard for the duplex on lot 134-06. I believe that's all we need, Brian, is that correct?
Yes. The applicant is here. Yeah, applicant is here if you need to swear him in. He's really not gonna say anything other than Brian's here to testify.
Do you swear or affirm that the testimony you give before this board will be the truth, the whole truth, and nothing but the truth?
I do. Brian Flannery Jackson, New Jersey, licensed professional engineer and professional planner.
Okay, and I'll swear you.
I think so.
Do you swear or affirm that the testimony you give before this board will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, and your name, sir?
Espinchus Wallhandler.
And you're the applicant?
Yes.
Okay.
The application is indicated is for take 2 lots to create a duplex on a 0 lot line and a single. So we have 3 lots. The property is in the R10 zone. If the board remembers, at the tech meeting, you asked the applicant to see what he could do as far as reducing variances. The resubmitted plans show 10 feet on the one side toward the neighbor on the duplex, so that conforms with the ordinance. So we did adjust it to reduce the variance relief that's needed. This property, I have A1 and A2. A2 is the per-cal map, and you see where the zones are. This isn't an R10 zone. Immediately to the west is an R75 zone, and then a little further to the east is the R12 zone. I only did, again, the blue in the immediate vicinity, and you can see how a majority of the lots in the immediate vicinity have variances and are more consistent with the R75 zone. And this planning board, in March of 2007, the master plan recommendation for this area, as indicated on page 74, was to rezone both R10 zones east of the downtown area to R75 to provide additional housing opportunities compatible with the redevelopment of that area. And A2, if it was R7, it would be a conforming application, by right application, right.
And we recommended it to the.
Yes, yes, yes. So going through the variances, as Terry indicated, they're in the R10 zone. We need 12,000 square feet for a duplex. The duplex lot is on 12,000 square feet, and the single-family lot is on 16,000 square feet. This is a very large piece of property, a very unique piece of property. The entire property is almost 28,000 square feet, and you can see on A1 there's a wetland area, and John would know the area very well. He lives a little further to the east. There's a wetland area in the back. Any of the area, when you look at the aerials, all the trees that are shown on the Google Maps, most of that is because it's wetlands. This is a unique lot. You look at the other lots, they're not as wide as this, and they have existing homes on them. Looking at A2, and I didn't add the area above this to the north on sheet 50, but I'm sure the board knows that whole area is duplexes and townhouses and all development that kind of exceeds the R75. So this really should be zoned R75. If it was zoned R75, it would be a variance-free application. Lot width for the single family, because it's the R10, 75 is required, and we're asking for 52. Side yard setbacks, for the single family, we're asking for 7, consistent with the R75, where 10 feet is required. Combined side yard setbacks is 22 instead of 25. 15 it would be what would be required for the R75. The lot width for the duplex, we're asking for 62, where 75 is required. In the R10, 60 would be required in the R75, so we would comply. And the minimum side yard setback, also 7 feet, where 10 is required, 7 consistent with the R75, which is consistent with the area that this is located and consistent with the recommendation of this board in the 2007 master plan, also consistent with the smart growth plan, where this is designated in the downtown regional center and the Downtown Regional Center per the Smart Growth Plan, which was adopted as the land use element of the master plan by this board on page 13, indicates that the Lakewood's downtown is the historic heart of the township. It contains identifiable commercial district surrounded by high to moderate density residential neighborhoods. So this certainly complies with the Smart Growth Plan and the vision of the Smart Growth Plan. The master plan of 2007 with respect to housing also indicates on page 35, there's been a tremendous residential growth in Lakewood in recent years, and the conclusion is not all of the housing needs are met. The same plan on page 56 says encourage development and redevelopment based on smart growth planning principles, which this does. Under the purposes of the Act, the Municipal Land Use Law, NJAC 40:55D2, A is to encourage municipal action to guide the appropriate use or development of all lands in the state in a manner which will promote public health, safety, morals, and general welfare. And this is the appropriate use of this unique piece of property. E says to promote the establishment of appropriate population densities, concentrations that will contribute to the well-being of persons, neighborhoods, communities, regions, and preservation of the environment.
And the rest of the report, you.
The rest of the report, we will comply with Terry's recommendations. He had a comment on the off-site wetlands, and nothing will be built within 50 feet of the off-site wetlands, so there is no wetland impact by the proposed development.
One question. The 24-inch pipe that goes back there, the easement isn't, the width of the easement isn't laid out on the drawing. Who owns the easement? Was that turned over to the township years ago?
I would imagine it's an easement to the township, and
It was, it's not delineated.
we would certainly clarify that during resolution compliance, and whatever the board engineer recommends with respect to that easement.
Who's it to?
Well, they already own it. It's the town.
But it doesn't say. I've been told that it is an easement to the township, and we would certainly agree as a condition that to provide the documentation to Terry that it is an easement to the township. If it's not an easement to the township, or if it's insufficient width, we would agree to provide that as part of resolution compliance.
Okay, thank you. Any other questions, any board members? Seeing no one, we'll
I have
open.
a question.
Yeah, Mr. Grumberger.
It looks like that the property with the single house, the backyard looks like it's like an L, is that, am I saying
Yes,
that right?
yes.
Why is it like that? Why is it?
Well, the duplex needs 12,000 square feet, so we took the 62 feet and made 12,000 square foot lot, which is what the duplex wants, and then the single family is gonna have a nice, big, large,
You needed that extra piece for the 12
The lot area.
well, the L shape in the back wasn't needed for the 12,000,
But not?
was not.
So why don't you just make them straight?
Because this will make a nicer lot for the single family. The single family will have more area, and it's a decision that the applicant made.
It's just simply there for the single family to have a bigger backyard. I mean, if you see the duplexes themselves have like 75-foot backyards, the way it is now, so, which is much larger than anything else in the neighborhood.
Thank you. We'll open it to the public. Anybody from the public like to be heard on this application, please come forward. Seeing no one coming forward, we'll close it to the public. Want to speak? We have a motion on this application. Moved by Mr. Hibberson, second. Second, roll call.
Mr. Grunberger.
Yes.
straightforward, Chairman, as indicated in our letter of January 19th. There is a variance that's requested with respect to mineral lot width, as well as the proposed building coverage.
No.
And again, this is an amended application.
There's, on the chart, it says it's a front
That-
yard. Lot 7.
Could I-
Quiet.
I do. Glenn Lyons, professional engineer, professional planner, Lakewood, New Jersey. The only two variances we're requesting tonight are for lot 7.09. All the other variances that are listed in the schedule were approved previously by the board. It turns out that the two things were missed when we were here originally. One, the resolution, we had a 60-foot, lot 7.09 is 60 feet wide. It was 60 feet wide on the original application, but it did not end up in the resolution that the board granted that variance. We had provided testimony at the previous meeting. This was originally part of a prior subdivision which had 3 50-foot wide single-family lots. And if you look on the, A1's our site plan, A2 is the Perkelman. There's several lots in pink. Those are all, they are all of the existing single-family lots within this 6-block area. They are all 50 feet wide or less. So they're all undersized 50-foot wide lots. So what we were proposing on the original, which was approved by the board, although it wasn't in the resolution, was a 60-foot wide lot, which is in keeping with the neighborhood and in keeping with the lots directly to the west. We missed the lot, yes, we missed the lot width variance. It wasn't in the resolution. And the second is, because of the way some of the ordinances were recently revised, everything in green on the map is permitted at 35% lot coverage. All the duplexes, all the townhouses, everything that's already built, which is in all the green on this on the Perkel map, they're all allowed 35% lot coverage. The 3 lots directly adjacent to us, to the west, which were part of this original subdivision, which you had 3 residential lots and a lot for a bank, which we re-subdivided. They were approved based on the RM zone standards, which 2 years ago were 30%. They're also now at 35%. So our lot, which is the lot I've colored in red, is the only lot within these 6 blocks that has a 25% lot coverage requirement. So we're requesting to go up to what's permitted in this, actually, for the duplexes, they're at 35%.
I don't understand what that, why are you going different than everyone else? I don't understand where that's.
Because for some reason, the ROP zone for single-family houses is 25%.
So it's because you're single family
Because
as
we're-
opposed to duplex or house.
We're not a duplex, we're not a multifamily, we're not in the, we're not the 3 lots that were previously approved on basically this larger parcel,
Duplexes are permitted to have a larger lot
35% lot coverage.
than single family houses.
Right, so only this one single-family lot,
If you were building a duplex here, you need no variances.
correct. I wouldn't, right,
That was the mistake.
that was the mistake that was,
Like single family.
correct. So,
There's nothing changing on this application.
nothing's changing, it's just
No problem.
what was not in the resolution,
Thank you.
so we're just coming to correct.
Questions from any board members? Seeing no one, we'll open it up to the public. Anybody from the public like to be heard in this application, please come forward. Seeing no one come forward, we'll close the public. Anybody make a motion on this application?
Second.
Okay, we have a motion and a second, roll call please.
Mr. Grunberger.
Yes.
Mr. Franklin.
Yes.
Mr. Hipperson.
Yes.
Mr. Herzl.
Yes.
Mr. Flansbrough.
Yes.
Mrs. Zagrafo. Mr. Cotillo.
Thank you.
Thank you. Good luck.
Last application is SP 2219 for Congregation Mishkan
Chair. As indicated in our letter of February 1st, there were some submission waivers. I don't know whether they were acted upon or not. We don't have them listed as acted upon. C13 EIS, C17 design calculations. Were they acted on? This is a revised submission.
Waivers were acted on December 20th meeting.
Okay. So that wasn't, all right, so the waivers were acted on. For our review of the plans, and we'll get confirming testimony from the applicant shortly, it's our understanding that no bulk variances are currently requested. We had a question about parking relief, which again, we'll talk about. There is buffer relief which is necessary with regard to the 20-foot buffer from a residential use. That would be variance relief, although not typically called variance per se. And also relative to our original comment about the language for curb and sidewalk along East County Line Road. The revised plan showed curb and sidewalk, and the plans indicate that they are being provided by the county. And the design waiver also sought from providing curb along Lucerne Drive, and I believe that is part of a prior CAFRA application. I believe that's all of the relief, is that correct?
I believe so. Mr. Chairman, John Doyle, on behalf of the applicant, privileged and pleased to represent congregation that is here before you tonight, Michigan Torah. We'll hear from Rabbi, and we'll hear from Glenn Lyons. So I realize we're running against the clock, so I'll be quick. Suffice to say, we're the last applicant in, and I thank all of the people who are behind me that are supporting this application. Rabbi, please affirm.
Raise your hand, sir. You swear or affirm that the testimony you give before this board will be the truth, the whole truth, and nothing but the truth?
I affirm.
Okay, would you please state your name for the record?
Aryeh Rubenstein.
Thank you.
Rabbi, what is your relationship to the applicant, please?
The rabbi of the yeshiva at 1017 and 1015 East County Line Road.
For how long has the yeshiva existed at any location?
Yeshiva was founded in 2003, and we moved to this location in March 2006.
So that we might create a full record in case it is needed, we might use the term yeshiva with a certain degree of familiarity, some with more than others. Would you define, as you know it in the community and generally, what is a yeshiva?
Yeshiva is a post, different types of yeshivas, but generally elementary school is called a cheder, a school. Yeshiva could either be a high school or post-high school. Our yeshiva is a post-high school. The sign in the front says Yeshiva Gedola, which means absolutely and only post-high school, meaning adults, rabbinical college, 18 and over, 18 to 21 actually.
The planner's review, engineer's review, as well as the facts the board would want, caused me to ask a few questions. The number of students proposed that actually exist in the school?
Varies from semester to semester. It's between 30 and 40.
Now, this site, you say it's been used previously. There were two structures built, I think, in approximately the 1980s that have been used as the yeshiva since you mentioned in 2006.
That's correct.
And as a yeshiva, there are presently dormitory rooms and students who live there.
Correct.
How many of the student body lives there?
In general, everyone. Meaning, excuse me, by definition, a yeshiva for post-high school students, definition means that everyone stays at yeshiva. It's 24/7. That's what it is. That's how all yeshivas are, both in Lakewood, both locally, and all yeshivas I know of in the United States.
And just staying with the township of Lakewood, there are yeshivas nearby to you, are there not?
Correct.
Another one on East County Line Road, a little west of you?
There's one a few blocks west of us. There's some east of us. A number of yeshivas. They all have dorms.
And I would ask that the board take note of the resolutions issued in SP 2129, SP 2163, and by reference include the resolutions in the record that allowed those as a permissible accessory use, that being dormitories as a part of a yeshiva. Would you therefore conclude that it is incidental to the yeshiva, to its school function as a yeshiva, to have dormitory?
Definitely.
Is it customary?
Definitely. As I said before, I don't know of any yeshiva that doesn't have a dorm.
So, there would not be students who would be driving or parking at the school. There would not be parents who would be driving and parking at the school, or students who would be dropped off or picked up by a car.
No.
Okay. Now, the existing buildings have dormitory rooms. This application is for an addition that would be a structure between the two existing structures that now exist. What is to happen in the newly proposed structure?
There's a basement and a first floor. In the basement, there's going to be a dining room, bathrooms, office. On the grade, there's a first floor at grade level. There's going to be a large classroom, a library, coat room, perhaps another office, and a lobby.
So you're not expanding the dormitory space, you're expanding the general service space, if I might use that term, the classroom and the office and the hall and the bathroom.
That's correct. We're not building more dorm rooms in that addition.
And is by square footage and the basis of its existence, the predominant and principal use is the teaching, the school, and as an accessory to that is the dormitory under the traditional yeshiva model?
The focal point of the yeshiva is the study hall. That's why we're there, and that's what we do most of the day. And being as such, the dorm is an accessory. As I stated before, yeshiva means, in definition, it means that we're there 24/7.
Subject to the board, I have no further questions of the rabbi and would go to the engineer.
What's the maximum amount of students that you, the future growth, you plan on going over 40?
I don't have any plans one way or another. I don't have any plans one way or another. It's the point of the addition is not to enlarge the school. That's not the point. But I'm
You're only building one floor, anything
One
else you
floor.
want to build, you're coming back to the board. If you want to build more.
whatever the law is.
We would acknowledge that an additional structure that would take a building permit would have to be preceded by a zoning permit, which wouldn't be issued unless there was a amended site plan approved.
Any parking variances on it?
As I read the parking standards, we needed a space for each of the discrete services, for the kitchen, for the dormitory, for the office, and when you added up one per purpose, you came up with either 4 or 5, and we're providing 6 spaces, so we meet the parking requirement. There was a concern raised that the original plan showed a gravel driveway, and that was raised understandably and appropriately by Mr. Franklin, and it will be paved.
I think we should swear in,
Mr. Lyons?
Mr. Lyons.
Thank you, Rabbi.
Do you swear or affirm that the testimony given before the board will be the truth, the whole truth, and nothing but the truth?
I do. Glenn Lyons, Lakewood Township, professional engineer, professional planner.
whose expertise has been recognized by this board tonight and for a number of years and in other towns also. Correct?
Correct.
You're familiar with the plan, you've had this property, the zoning ordinance, you've had a chance to review the February 1st report from the board engineer, Mr. Vogt.
Yes, I have.
And moving to page 3, the waivers having been granted and the description of the application generally being accurate. Number 2, Roman numeral 2, paragraph 2, it appears that no bulk variances are being requested. It is your judgment as an engineer and a planner that none are needed?
That is correct.
With respect to number 3, while it indicates that perhaps a plan showed an encumbrance into the setback, we will meet all of the setback requirements.
Yes, we will meet the requirements.
Number 4, with respect to parking, you heard what I had to say. Do we need a parking variance?
No, we do not.
With respect to number 5, buffer relief is requested. The ordinance says we are to show a 20-foot buffer. In fact, we have a structure that pre-exists that is 14 and a half feet away from the property line.
Show where the buffer is on the.
Yes, we're providing, County Line Road is to the bottom of the plan, just for orientation. Lucerne Drive, which is on the west of the property, is to the left on the plan. Along the rear property line, we have a 20-foot wide buffer that stretches from the front setback line to the northeast corner of the property, and then that buffer extends up to the back of the existing house, or, I'm sorry, back of the existing structure, which is the dormitory. That structure is 14 and a half feet off the property line. So at that point, the buffer can't be 20 feet wide, it can only be 14 and a half feet wide.
It would have to be, we'd have to knock 6 feet off the building to meet the 20 feet.
That's an existing condition. That's the.
And that would be the hardship,
Correct,
undo as it is.
correct.
Are you proposing any landscape buffer there? Is that
We,
necessary?
we propose currently a row of white pines along the rear property in addition to a 6-foot vinyl fence. We do not show buffering on the easterly property line. There have been discussions, as the board's aware, with one of the neighbors. They've made some specific requests which have changed over time. And that's lot 50.05 as to what they would like to see as far as buffering in that northeast corner. We will provide what they would like.
How far are you from the new construction to that corner?
Probably from that corner to the rear of the house that's under construction is 50 to 60 feet from the rear of that house.
Can I see clarification, Chairman? I think I just heard that you're going to provide landscape buffer to the satisfaction of the neighbor?
No, we're going to provide reasonable landscaping to the degree that there was an indication that there was a desire to have trees along the eastern side, mindful of the fact that the only common boundary is the 20 feet at the northeast corner, but site distances and abilities might be greater. We would provide whatever the Shade Tree Commission feels or this board feels is appropriate. There was mention made of trees 8 feet at planting. That's certainly reasonable. The height is a little higher than I think the ordinance would require. Usually you'd see something 5 to 6, but we'll be reasonable and follow your recommendation.
I just want to make this clear that if the board acts favorably, we know how to enforce this.
There was mention made of particular types of trees, arborvitaes, and certainly we'll consider your recommendations from the engineer.
That's only on that corner.
No, we have trees across the whole 20-foot in the back. We will add to that by coming down the easterly side. And I think, obviously, if there's a concern raised between now and compliance, we can work together With respect to the curbs and sidewalks mentioned in 6, the county is gonna come in with curbs and sidewalks because of the road improvement on East County Line Road.
That's correct, and we showed those on the plan.
The curbs on Lucerne, they were not required as a result of the CAFRA permit, and we will try to provide the CAFRA permit, but we can't get it amended 20 years later.
Correct.
So your testimony is that you're seeking the waiver because there's an existing CAFRA permit that precludes you
Correct,
from
that
putting
it,
in curb and sidewalk?
the entire development, Lucerne and all the development behind that, part of their CAFRA requirement was they were not supposed to have curbs. They're supposed to be just grass swale along the edge of the road for recharge and water quality purposes. So if we put curbs in, it's against the CAFRA permit.
So if the
We
board
can-
acts favorably including this waiver, it will be contingent upon you providing proof of that.
Correct, we will provide a copy of the CAFRA.
It may be a policy issue in terms of the way stormwater is handled.
I heard reference to that recently, I don't think it was in association with this project, but that CAFR often will recommend not curbs.
Right, at the time this was approved, it was this project, and there was another one over off New Hampshire Avenue. Neither of them were constructed with curbs. The idea was let the water flow off the edge of the roads, let it percolate into the ground. And so it was built that way.
With,
This is part of that whole
Correct.
For parking, we've spoken to, with respect to refuse enclosure, we will follow whatever the board's requirements are with respect to location of trash removal.
Correct. Currently, it's out close to County Line Road. We're working with Public Works to find a suitable location that they'll be happy to pick up garbage from.
6, the HVAC will be on the ground, and we will put up vinyl screening or
Well,
shrubbery.
it's on the ground next to the building, and we're already providing fencing around the property and landscape screening along the rear and side property line. So I think with the buffering that's being provided along the property line, I don't see where we need additional screening next to the building.
I missed one. We do not intend to have any school buses, and that goes to an earlier comment, and in terms of number 7, we, as a result, don't need anything larger than a passenger van to service the site and its purpose.
That's correct, and the site has not been designed for school buses.
Number 8, about the radial dedication, and 9, about the consolidation. We'll do that.
Correct.
We will take care of the easement mentioned in number 10, and the easements mentioned in 11.
10's the widening the shade tree easement to 10 feet, we can do that. The others show any and all easements that are on the property, I believe we had, but we will definitely provide those.
We show in the existing improvements on the plan, do we not?
Yes, we do.
With respect to number 13, we agree with that recommendation and we'll follow it.
We can provide those calculations, yes.
Same is true as to number 14.
Yes, that asks for the calculations again, and any maintenance of the recharge system will be the yeshiva's responsibility.
In number 15, in bold, we recommend proposed buffering be added to the east side of the property, and we responded to
We've
that.
discussed that, right?
16, we will resolve the lighting plan as mentioned.
We will complete the lighting plan. We did show the lights, we didn't provide the point-to-point diagram.
Don't go on to the neighbor's property. Is that fine?
Correct, no, it's really just intended to light up the small 6-car parking lot. We only have 2 small fixtures.
Um,
Are there any concerns about privacy being overlooked by any neighboring facility or vice versa?
There's only one floor house with the whole school.
I was thinking of
You mean
I don't understand the question.
the privacy of our neighbors because of the existing structure? The structure has existed for, the existing structures came first, so the people who are neighbors made the judgment that they were prepared to live next to a yeshiva that includes dorms. We're not aware of any, the concern that we heard from the neighbor who doesn't live there yet was that if we were to go up, would we be prepared to frost the windows or to make sure any window was at least 7 feet above the ground? And we would be if we were to go up, but that's not a part of this application. I think I left you at 17. The water company put the lines on Lucerne, and so we expected it on East County, but it came out on Lucerne, and we'll connect and change the plans as required.
Correct.
And 18, we don't expect to have a signage. Rabbi mentioned the sign, which is flat against the
On the
wall.
building, right. But there's no freestanding sign proposed.
And we understand we have to get the regulatory approvals.
Correct.
Taking everything into account, let me ask you, as a planner, are you satisfied from what you've heard from the rabbi, what you know of the way the property is operated, that the dormitories are in fact a customary and incidental accessory use?
Yes, they are. We've proposed them and gotten them approved by this board several times on other properties.
And you're aware that the zoning officer of the municipality has opined, that is Mrs. Siegel, that in fact dormitories are an accessory use?
Correct.
Are you satisfied with respect to the site plan? We've met all of the comments, and that if there were any variances or waivers that were needed, that there was the statutory requirements of either hardship or appropriateness are met?
Yes,
And that the benefits would outweigh the detriment?
they definitely would.
I have nothing further, Mr. Chairman.
What's the technical engineering review number 2?
Technical engineering comment number 2?
No, I see there's no.
It's,
That is the normal, really detailed engineering that oftentimes is done at compliance, and we, Mr. Lyons, you've reviewed that, and we're prepared to meet that.
yeah, we've reviewed that document, and we have no problem with that.
That's me. Any questions from any board members? Seeing none, we'll open up to the public. Anybody from the public who hasn't heard of this application, please come forward. Please state your name.
My name is Charles Benatar. I live at 3 Davos, Lakewood.
Sir, raise your hand. Do you swear or affirm that the testimony you give will
I affirm. I'd just like to testify here in front of the board that I was a neighbor of before the yeshiva was built. The yeshiva was built. It's been a very good neighbor of ours, and we're very honored to have the yeshiva, very proud of the boys.
Where do you live?
I live on Davos, right by Lucerne. There's a cul-de-sac.
Plan? You,
Not familiar.
Yeah, we actually don't show.
Not showing? Right, where's Lucerne?
Lucerne's here.
Okay, right here in Lucerne, I'm on the cul-de-sac.
There's a
right-
cul-de-sac
you're.
Right.
Across the street.
to the west.
And there's never been any issue as far as questions about parking or any invasion of privacy or buses or anything like that. And ask the board to please approve this application.
Thank you. Anybody else from the public like to be heard?
Sir, raise your hand, please. Do you swear or affirm that the testimony you give
Got
will
about
be
4 minutes,
the
after
truth,
9
the whole
o'clock.
truth, and nothing but the truth?
I affirm. By the previous public, whoever spoke in the public, you didn't put on the clock. I stand up and you put on that clock. Now, the reason why I'm having, please, it's my time now. That is better. The reason why I'm mentioning it again, because obviously this whole thing is in court. And it would be a good idea, the judge in this case, I assume the attorney will make an issue about that you try to limit with that clock 4 minutes public comments on an application when that when it's technically, accordingly to my understanding, illegal to differentiate between an attorney and the public comments. So this is totally illegal, and I hope the attorney on this case makes an issue about it. And again, if you're not sure about this, why are you doing it? Just make sure about before you're doing something and then do it. Now I'll go to the application. Curbs and sidewalks. Is it missing over here or not? You know, my understanding is some curbs and sidewalks are missing. And they're claiming that there's a CAFR permit. I don't understand. Last application, when they were here last time, there was also mentioned something about curbs and sidewalks by Mr. What's your name? I forgot. John Franklin. And there's a sign over there, so I was able to read it. And Mr. John Franklin made an issue about it, and they said that CAFR does not allow them to do the curbs over there. I wonder if the applicant even applied for Oprah. You know, we keep on doing by the state Oprahs, and we get it right away. We provide by the township Oprahs, we get it, except of closed sessions, we get everything. But they could have applied for Oprah, and I'm assuming if you ask them if they applied for one, they'll tell you no, we didn't. Oh, it takes a long time.
I think they testified before that the county is going to put the sidewalks and curbs.
There's two curbs and sidewalks. One is on the street on Laterne Drive. That they're claiming is a CAFRA issue. The one on county line, that's a county issue. There's two different issues. So as far as the CAFRA problem, what they're claiming that they have, they never applied for finding out what CAFRA is permitting them to do or not. I'm not saying, and I'm against it, you shouldn't approve it, but the end of the game is, curbs and sidewalks is a safety issue. And when applicants come in and if it's a yeshiva, I don't care if it's on Biltmore, if it's on this street, if it's on that street, if they're coming in and they're trying to get around it, it's not fair. You know, but the planning board, when it came to the Chestnut and Route 9, the applicant said, we have major hardship if you're requiring us to put in sidewalks. You got around it. You made them put in sidewalks over here, and not subject to the approval, but they would eventually have to put in sidewalks. The same thing over here. The county claims they'll put in sidewalks. Okay, so let it make conditional approval. If the township does not provide the sidewalks, they have to put it in, because by the end, if the township won't put in sidewalks, we'll end up without sidewalks over there, and it's kids, and it's county line, and it's dangerous. The same thing is with the curbs. If you don't have curbs, you don't have sidewalks, it's simply dangerous. So again, I'm not against the applicant, I'm not against the yeshiva, I'm not against anything. I'm just against the fact that they're trying to get around sidewalks. If their claiming is that they filed an Oprah request to find out what CAFRA is permitting them to do or not, I'll raise my white flag. But I'm assuming if you ask them if they did it, and I could cross-examine. So let me ask the applicant, did you file for an Oprah request to find out for the CAFRA permit?
We did not request, we didn't file an Oprah request. I know for a fact that curbs were not required. I was the township engineer at the time that this development was being.
My time is up, so I have to leave. Okay, we could continue.
I was the township engineer for Lakewood when this development was being constructed. I do remember seeing the CAFRA permit. I do remember the plans for Arosa Hill. None of the streets in that development have curbing. So, like I said, we have no problem going on the state's website, getting a copy of the original CAFRA permit, submitting it to Terry. I'm sure it's there. I'm sure that's the way it was approved. I have no problem with the testimony I've given.
I could testify as well as a neighbor that there is no curbs. Oh, affirmed again? Yeah, I affirmed. I affirmed it before. Charles Benatar. As a neighbor, I can testify as well. The whole area, there is no curbs, there is no sidewalks. So.
Now, most of the
sidewalks, but no curbs. Right. No curbs.
Thank you. Anybody else from the public would like to be heard? Please come forward, Mr. Hobday.
Do you swear that the testimony you give before this board will be the truth, the whole truth, and nothing but the truth?
I do. William Hobday, 30 Schoolhouse Lane. A question. Would the addition, with additional students, require additional transportation additional buses to come to the site.
Mr. Habda, you missed the testimony evidently. There are no additional students. The rabbi testified to that. The students live there, so there's no busing, nor there will be no, there's not busing one, never mind additional buses.
You're testifying that there's no busing at all, that those
No, Rabbi,
services this
Rabbi
year?
testified to that previously, 15 minutes ago when you were sitting in the front row.
Well, I heard that the students live there at the dormitory, but I didn't hear that there is no busing. That was never part of the testimony.
That's what he said.
Yeah, I understand it. The question was, will there be additional busing? And that's to determine whether all the students live there and stay there and are not transported there back and forth. If they're residents, they wouldn't need busing.
If I
And the
might,
question
Mr.
was, do they have, please, I have a right to.
I want the rabbi to answer your question.
Well, the question was about busing. If there's any busing that goes there, then I question how all this, why that is, because if all the students live there, they would stay there.
But from what we heard, I think the rabbi said that not only will there not be additional busing, there is no busing.
Rabbi,
I just want to hear somebody say it.
Okay, no problem, one at a time. Just please put it on the record.
yes.
Are there any buses coming to the site?
I could say that in all the years we're there, I don't think we ever had a bus there. I'm talking under oath, but I'm 99% sure that we not had a bus there in 12 years.
And so
Not one.
0 plus 0 is 0.
And there are no additional students coming with this application right now?
As I said before, the purpose of this addition is not to add students. I'm not promising that we're never going to have more students. I don't think you're asking me that. The purpose of the addition is not to enlarge the school.
Thank you, Mr. Chairman. I just wanted to get that on the record. No busing, no additional students unless
No problem.
things change. Thank you.
Anybody else in the public would like to be heard?
I'm very mindful, Mr. Chairman, of the question, is there anybody, and I see people starting to stand, and I'm also mindful it's 9:15. If you would, by way of, if all those people who are here and would wish to come up and affirm that they support the application, but understand that we're past curfew, those rising, let the record show that by my head count, there's about 45 to 50 people representing about 90% of the audience, if not closer to 100. I thank you all.
Okay, thank you. We'll close it to the public now. Would you like to make any closing comments?
Mr. Chairman, it is sometimes a duty to come. Sometimes it's an obligation. This was an obligation to do right. I hope the board, and I appreciate how they saw through this application and allowed us to present it. I heartily commend its approval. I hope you will. Thank you.
So just one thing to put on the record, you will try to satisfy all the neighbors who are opposing with the trees or with the fence, whatever's reasonable, you will put in.
I want to fairly state that Mr. Gazarovski and I have spoken. There's been an exchange of documents and conversation. There is, to my knowledge, only one objector, and we will try to meet his concerns. We appreciate that he has a house going up, that the yeshiva had been there, the sign clearly, and I believe Mr. Bodek would understand that. But to the point of the future, we want to be a good neighbor, as we would hope he would be. We are going to put the trees where we said. We're going to put the fence where we said. It should provide a visual barrier to 6 feet, the height of, the maximum allowable height of the fence. The trees are planted at a greater height, and they're growing trees. It'll still be more to create a green fence. So we certainly want to, we'd rather be teaching than lawyering and paying to go to court. And I hope he feels the same way.
And if you ever add a second floor, you agree not have the windows to be frosted.
And at least 7 feet or 7 feet above the ground, yes.
And one more question.
Yes, sir.
How far is Mr. Bolduc's house from the,
I think Mr.
it's about 100 feet?
Yes.
Roughly 100 feet away.
Correct.
I think, we need the 20/20 vision to see it.
I could put it, evidence the picture. If you were in front of Mr. Bodek's house, his house is a significant, lovely house. You couldn't see the yeshiva. From the back of his house, obviously, he has a somewhat of a vision, and we're gonna try to block that as much as possible.
Very, very little that he can see through.
The 20 feet is the common boundary. We'll all pray the trees grow quickly.
And his house is not by the boundary of the house.
No, it's,
More, it's further out.
It's an irregularly, almost five-sided property, and it's set more towards the front, so there is a large rear yard plus our setback, which we will meet.
So you agree that there's no privacy issues to him?
No,
The trees will be in?
no, he's got, again, 90 to 100 feet to the back of his house from our property. It's the rear yard of the school, the yeshiva. We landscaped that, our little piece or common boundary. I don't see any problem.
I just want it on the record, I know he's trying to oppose it. I just want to make sure that we address the issues from this
No,
neighbor to try to accommodate him, and there is no privacy issues. That's
Not that,
not-
not that we could do any more than we're trying to. I think the landscaping will really take care of everything as far as the interaction between our two properties.
Thank you.
We want the curb and sidewalks in, if the county doesn't put them in, they'll put them in.
You're talking
Yes.
about along County Line Road, they're gonna be installed by somebody.
And the corner, just
Yeah, I guess it's
make
about
the intersection.
Do you agree to that?
Yes.
Okay, do we have a motion? Mr. Hipperson moved, do we have a second? Second, we have a second. Roll call, please.
Mr. Grunberger.
Yes.
Mr. Franklin.
Yes.
Mr. Hipperson.
Yes.
Mr. Herzl.
Yes.
Mr. Flansbrough.
Yes.
Mr. Renner abstained, Mrs. Zagrafo, and Mr. Cotillo.
Thank you.
We have the approval of bills.
The meeting, you guys, the meeting's not over yet, we still got business to get through, please.
Yeah, I'll make it fast. Just want to mention about the problem of Biltmore and Cross Street. The engineer over here said, on the record, that he didn't do anything wrong. And I just want to clarify what's going on. When the ordinance, the UDO is very specific, that if you have a property that you're building, you have to improve the road accordingly to the RSIS standard. It doesn't say if you have access it or not. It says frontage. Frontage means front yard setback. That had a front yard setback. He wants to claim is he only mentioned it by the application, the small guy, where it came with 2 lots, and not by the Herzkes Yeshiva, that he has a lot of influence. And that is wrong. He shouldn't give special treatment for a yeshiva when it comes to safety. I am well for yeshivas, but not when it's a dangerous intersection. He didn't mention it over there, and he still doesn't want to admit that he made a mistake. And this is not talking about 1994. This is talking about 2016. It came for this board. And you know what? They came and they asked for a 30-foot setback on that side. You know what? It's only 21-something feet. On the plan, he didn't catch on to it. Nobody made an issue about it till now, but now I'm telling you, you didn't see that when they asked for 30 foot, it's only 20 foot, and the property now is on 20-foot setback, and it's not on 30 foot, and they only got a 30 foot, and the engineering department is not catching up on it. Maybe you need another motion to look up on that. This engineer is trying to basically what? But he's attacking our people, our safety. Building a sidewalk in middle of a road? It's crazy. You're still defending him? You know what? You know what? You know what? Okay. Thank you.
Thank you.
Not right.
It's closed.
You're not a professional. What are you?
I'm a member of the public that has to drive over there. My children are in safety, not yours. Where are your children living? In Lakewood?